So good afternoon and welcome everyone to the 2024 Presidential Summit. It's amazing in this weather the turnout we've had throughout this whole meeting, and I appreciate your dedication in making it to these various functions. I'd like to first thank our sponsors, ALM and Anytime.ai, for sponsoring this afternoon's discussion. So, when I became president, one of my first acts was to appoint a task force on artificial intelligence. Genius, don't you think? Because all you had to do is look at every article in every newspaper in the world, and all you did was see more and more and more on AI. And so we put together this task force, and then we decided that it would be a great idea to try to educate our membership about the various issues that AI does in confronting us and confronting our clients and confronting our practices. And we also have to get it across that AI is inevitable. We're going to deal with AI one way or the other, and sometimes lawyers would rather not get too involved with new issues. Unfortunately, there's no choice. This is an area that is probably moving faster than any form of technology in the history of the world. I don't know what happened today because I haven't seen a newspaper, but I'm guessing that there's some new advancement or some new problem or some new ethical dilemma that people are going to have to deal with and lawyers are going to have to deal with. So today we want to address how AI can best assist those who interact with the legal system and evaluate what protections must be in place to prevent commercial interests from ignoring ethical problems. We know that using AI comes with risks and that it's not a panacea. We are concerned with how it assumes the inherent basis of the inherent bias of who's inputting the information or the data into the system. We're worried about writers and artists whose copyrighted materials have seemingly been usurped by AI systems. We're disturbed about machines making decisions without the benefit of human judgment, and maybe we're even more concerned that these machines may eventually get human judgment, and where are we going then? So our first panel on generative AI gives us a real honor of having two world-renowned experts in the area. They're going to offer an overview on the potential of AI and the regulatory issues. The first person that I'd like to introduce is Judge McCormick, who is the President and CEO of the American Arbitration Association and the former Chief Justice of the Michigan Supreme Court. She lectures, writes, and advocates for the appropriate use of AI by members of the legal profession, and in addition, she is a strategic advisor to the Future of the Profession initiative at the University of Pennsylvania Carey Law School. Catherine is a partner in the litigation and technology group at Paul Weiss, and Catherine Forrest, also the former judge from the Southern District here in New York. She has lectured and written extensively on AI, including a couple of books, and she has a long-standing interest in consciousness and quantum physics, which led her to delve more deeply into AI. In addition, the judge is publishing yet another book in May that will focus on AI's cognitive abilities. And I'm sure that I'll read that and understand it completely. Judges McCormick and Forrest will touch upon how AI can help individuals who don't have and cannot afford legal representation, while AI can have a positive impact by creating efficiencies for everyone involved in the legal system. It is imperative that its systems are accurate, and reliable enough so that a person who otherwise could not afford a lawyer can, at least to some extent, rely upon them. We're going to have a second panel, and that's going to be entitled Leveraging Generative AI as a 21st Century Lawyer. And we are fortunate to have 4 experts from our association who will lead the discussion on how to best leverage the technology, specifically when it comes to legal research, document drafting, and client interactions. Vivian Wesson, who may not be here yet, there she is the chair of our task force on AI and the executive vice president, corporate secretary, and general counsel for the Board of Pensions of the Presbyterian Church. Ignatius Grande is the immediate past chair of our commercial and federal litigation section and the director at Berkeley Research Group and a member of our AI task force. And Marissa Moran is a professor in the Law and Paralegal Studies Department at New York City College of Technology, CUNY. And Ron Hedges, of course, is a principal of his own firm and a part of our AI task force as well. So, I want to thank the panelists for being here. They have taken time from incredibly busy schedules, although I don't know if you could fly, Judge, in this weather or not. So
I flew last night, I'm flying tonight, so.
Okay. So it is my pleasure to introduce our 2 panelists who are going to have a discussion about AI, and I'm sure that we are going to certainly learn from that. So thank you both. Thank you for being here.
All right. Thank you very much. And we're going to have today an interactive discussion. The way we've set this up is by taking a little bit of the lead on some segments, but really posing questions to each other to get sometimes similar and sometimes slightly differing viewpoints. But we also want to encourage you folks, to the extent that you've got questions as we go along, to ask them, though we'll have a Q&A at the end in order to take up any questions you have at that point. You've already had our introduction, so let's just give you a little bit of a sense as to where we're going. We're going to start off with an overview of what is this thing that everybody is talking about called generative AI. Some of you may know a lot about it, some of you may know less about it. We're going to be talking about some of the new advances in this area, because it's not just what came out with ChatGPT. We'll then be talking about the realities of the transformative potential of generative AI, what's real in terms of the transformative potential, whether or not certain things have been oversold, whether or not it's just hype, or whether or not there's a new world a-coming. And we may have differing views or similar views on that. We'll be learning that as we go. We'll talk about something that all of us probably are very concerned with, which is how is the law going to catch up? Because we not only have technologies that are going to be changing the practice of how we do law, but it's going to be changing the kinds of cases that come to each and every one of us. Because when an AI is embedded in every single industry, it's going to be changing the nature of the cases that come before everyone. And so we'll be talking a little bit about that. We'll be talking about preparing ourselves then for this new world of generative AI. And then lastly, we're going to take a few minutes at the end to talk about what we think the future might hold, which will be our own individual views on where are we going, where do we go from here, what's the path forward, however we're going to wrap it up. So I'm going to now turn it over to Bridget, who's going to start off on the first segment.
It's great to be here. Thank you all for showing up. It's really a pleasure for me to get to present with Catherine Forrest, whose work I have followed for some time. She's been at this for a very long time. I'm the newbie, but I have jumped in with both feet and been spending a little bit of every day on this topic since last fall with a bunch of my teams and teaching it and doing everything I can to get up to speed. So I can probably whip through this first section and get to the discussion part, which I think will hopefully be the most interesting part. But I want to walk through some of the basics just to make sure we're on the same page. But before I do that, by a show of hands, how many people have used any of the generative AI products that are out there in the wild? ChatGPT, Claude. How many people use them regularly? Keep your hands up. How many people use them every day? How many people are using the products that are built specifically for the legal profession, co-counsel or the VLEX product? Okay, good to know, helpful. So obviously artificial intelligence has been around for a long time. There's a reason why Netflix knows what you want to watch next. They have been studying a lot of data about your preferences, and they can predict what you want to watch next. AI has been in your lives for quite a while. Generative AI is different. Generative AI actually creates new content. It produces new information as a result of questions put to it after it's been trained on a whole lot of data. And this is what's new. Well, I take it back, it's not new, because AI obviously has been training on data for a long time. And it is learning algorithms based on patterns it recognizes in that data. And that's fundamentally what it is. It's pattern recognition. And so that's something that we've all been living with for some time. But starting at about November 2022, we all started talking about generative AI for the first time. Although I will say, I think many people say AI when they mean generative AI, and some people say generative AI when they really mean old-fashioned AI, sort of pre-ChatGPT AI. Generative AI, GPT stands for Generative Pre-trained Transformers. There have been lots of other examples of general-purpose technologies throughout our history, and many of them have changed our society in fundamental ways. The printing press, the steam engines, electricity, arguably the internet. And when OpenAI released ChatGPT last November, I'm told they didn't know that it would have quite the impact it has had. But there are many who believe that this is the next big change in how we do business, that this is going to have a tremendous impact on lots of what we do, and certainly on the legal profession. It was a breakthrough moment, November of 2023, when ChatGPT was released. As you know, shortly thereafter, other companies released their own models, their own generally trained models, and some of you have used many of those. Goldman Sachs estimates that investment in AI technologies will exceed $200 billion by 2025, just to get a sense of how enormous the market around these technologies is. This is a slide that I think captures something fundamental about the change we have seen as a result of ChatGPT's introduction. Every one of these technologies went quickly to 1 million users when they were released. I mean, I think quickly. I think even 3.5 years when Netflix was released, that was viewed as a very fast growth to 1 million users. It took ChatGPT 5 days to get to 1 million users. And this is the data point that I usually use with legal audiences, and I've been doing a lot of presenting to judges in different states, that I think captures their attention or arrests them a little bit. When ChatGPT was released in November, a group of scholars led by Dan Katz had ChatGPT take the Unified Bar exam. It did not pass. It did. I think it failed. I think it passed 2 of the 6 multi-state subjects, but it failed the exam. When ChatGPT 4 was released in March, just a couple of months later, it had just a couple more months of learning from new data and from all of those users who started using it. It not only passed the bar exam, it scored in the top 10%, and it did it in 6 minutes.
And it didn't go to law school.
Yeah. Doesn't get hungry, doesn't need to go to sleep. It's a stunning technology. It also is one that I think has tremendous potential to have an impact in our profession for a number of reasons. We actually have a lot of structured data in law. Regulations, statutes, even judicial opinions are structured-ish, right? They often follow a particular template, and they are therefore common enough and uniform-ish enough that they are well made for large language models to train on. And as we'll talk about, there are some companies that have trained specifically on legal information. So when you present on this topic, Catherine, how do you explain AI or generative AI? How do you talk about it to people?
Yeah, so what I do is a combination of this very broad overview of what you've done, Bridget, and then I also, though, sort of pause and talk about why AI to begin with. Why AI now? What's different today where we're suddenly hearing about AI? And why did the ChatGPT world suddenly hit our radar screen in November of 2023? So first of all, AI started to be talked about in 1956 at a very famous conference called the Dartmouth Conference. And even before that with Alan Turing, who was a very famous sort of code breaker during the Second World War. But there was sort of an up and down with AI that had to do with a number of things. But what came together? What came together in the late 90s and in the early 2000s that allowed for AI to be adopted in the financial services area for algorithmic trading, which is incredibly fast trading with complex algorithms because it was already in use then? What allowed AI in the late 2010 timeframe to start being used for credit cards and loan loss, figuring out loan losses, and for human resource tools, a lot of what we call narrow AI tools, tools for a specific purpose. What came together were two things: computing power and data access. So you had to have those two things, those constituent components, to really allow for AI to take off. So one of the first things I do with audiences is when they say, well, why AI now? I say, well, the first thing that happened was we had the advent of relatively inexpensive and very extensively available computing power. We had the advent of the cloud servers that allowed us to put a lot of data generated from the internet, huge data sets, digital data sets that could be stored, that could be available through the internet or through proprietary databases. Those things together allowed for the complexity of the narrow tools used in a lot of industries that were single-purpose tools, used for human resources, used for credit card companies, used for directed marketing, used for Netflix to do some targeted marketing towards you, used for Pandora, used for any of the music services that try to put together the kinds of playlists that you like. That's all narrow AI built on this data. What happened with ChatGPT is they were suddenly able, through the extensive development of, frankly, some neural network technology, very complicated, multi-layered technologies that we'll probably talk about just a little bit, we'll touch on a little bit, because they become black box technologies. But these neural network technologies allow for the ingestion, the taking in of huge amounts of data, that data to be processed within the neural network in a way that no other huge set of information has been processed, and to spit out output. When does it spit out output? In response to a human being just asking it a natural language prompt, an NLP. That means you can go up to a neural network, you can go to ChatGPT, which is running on a neural network, ask it a question, tell me what X, Y, or Z means. And it will give you a paragraph answer. That paragraph answer is not Wikipedia only, although it probably incorporates some Wikipedia, but it incorporates really everything scraped from the internet. And how does it do it? It's working on, as Bridget said, data, data, data. It's taking vast amounts of data from the internet. It's taking it in the pipe. I call it a big pipe going in, a big box right there, that's the black box, and a spout. Think of it like that. That's a neural network. The ingestion from the pipe, you suck that data in, it whizzes and whirs around that big black box. The data then is weighted. The more of one kind of data, it rises to the top. The less of one kind of data, it goes someplace else. So it's weighted data. What that means for all of us is that our world is good and our world is bad. And the good and the bad and the ugly contained on the internet is what makes the AI tool think. So if the AI tool is absorbing the data to work, it's absorbing the world we have given it. It's a baby opening its eyes inside the internet. Think of it like that. It's a little scary, right? If you think of some of these places on the internet, right? But that's how it then takes all of this data, and what it can do, what generative AI can do, as Bridget's explained, that regular AI can't do, is it can do not only the human resources task, but it can also do the other tasks. It can also write your resume. It can also write you a bedtime story. It can also tell you about what the best bread recipe is and walk you through the various steps. So you've gone from narrow AI, trained on narrow data, to a broad tool trained on all of the data it can get its hands on. And it can do broad tasks in literally every industry. So no longer is it about inventory management at Walmart. No longer is it about just looking at one little segment tool for your Roomba that runs around your living room and uses some visual aid technology and runs into and sucks up your carpet. You know, it's not doing all of that. It can do everything. So what I say to people is, those are some of the differences, narrow and broad, but all of AI is data, 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 and pattern recognition from that data.
That was super helpful. I don't think I can improve on that, but I want to add one thing to the history is really important. I mean, it is also the case that technologists have been working on this neural network technology for many decades. That was a surprise to me when I started my learning journey, but I highly recommend, if you haven't read it, the book by Cade Metz, Genius Makers, which tells the story of the history, and it tells it in kind of a Michael Lewis book kind of way. So it's a fantastic read if you get even a little bit interested in this topic. Okay.
Can I make a plug for a couple of other books, as long as we're on books?
Yeah.
And then we'll get to some articles, too.
Yep.
But if we're on books and you're really interested in this area as just a sort of a starter pack, right? Max Tegmark's book, Life 3.0, great book for a starter sort of AI overview, right? Then The Weapons of Math Destruction by Kathy O'Neill is also a really very interesting book. And then The Master Algorithm by Pedro Domingos will tell you about all the complexity of all of the algorithms. All of those you can get on Amazon, and they're all nice little sort of overviews, all very readable.
And honestly, you have the ability to actually catch up with the people who know the most about this in the legal profession just by reading a few books this weekend. All right, not quite. You won't catch up with Catherine, but you'll catch up with a lot of people. Okay. Some people describe generative AI as just memorization, spitting out something that's already been memorized. How do you respond to that?
So I think that a lot of you will have read, starting in really November of 2023, and so much has happened, right? We're at sort of the one-year anniversary-ish, right? Right around one-year anniversary. And so much has happened between our understanding of generative AI in November of 2023 and today. And so it used to be that in November of 2023, and some people you'll hear saying this today, and some of you may actually believe it. I don't know what Bridget may say, but there are many people who would say, well, what generative AI is really just taking in words and in a very sophisticated way doing a fill in the blank for the most likely next word. And so it can learn about context, and it sort of just fills in the next word. So
if you had the cat in the...
Right. The cat in the...
It would predict hat. And that's how some people describe it.
And that's what it would do.
Yeah.
Now, in my view, we've moved away from that. And we've moved away from that in terms of the understanding of what generative AI does. And let me sort of go back for a moment and describe how that happened. First of all, there were a number of these large language models, these LLMs, which ChatGPT is built on an OpenAI LLM. And many of them were released into the open domain. They were released out there and put into the wild. Llama was released and a number of others. And so what did that do? Well, first of all, one of the reasons, was it altruism? Maybe. It was also to have millions of people experiment on what these models could do. And they learned, everybody learned, the research scientists learned about what are called emergent capabilities. E with an E, emergent with an E. Emergent capabilities, meaning that there were capabilities of LLMs that even the people who had developed them did not understand that these tools could do. So I came with a couple of articles for you folks. I recommend, if you want to really look at different articles, to look at a website that gives a lot of academic articles. They're for free, called Archive. It's spelled A-R-X-I-V, Archive. And if you search artificial intelligence, and then it will give you the most recent, and you can scroll backwards, you will see that literally every single day there are articles that are published. But one of them that I wanted to point out to you was an article in September of 2023, which is called Are Emergent Abilities in Large Language Models Just in Context Learning? In other words, are the abilities that these models are showing us just the memorization of words from the context around them? And the point of this paper, which is done by some researchers both in England and in Germany, is no, that it's more than that. They have discovered that these large language models actually have developed their own ability to learn with their own, they'll write their own code. They have linear learning models that they have themselves written and embedded in their own code. And so there are a number of emergent capabilities that are not just memorization. But let me just say one more thing, and then I'd love to hear your view on this. But one of the things that generative AI can do that's so phenomenal is it can ideate, which I never knew was anything other than idiot. But anyway, I've learned about the word ideation. And ideation, coming up with ideas. One of the things that AI can do, and generative AI can do, and it can do this with some legal tools, Harvey being one example. There are a number of them, but Harvey's one example that I've spent a lot of time with, is it's able to come up with ideas. Coming up with a novel idea in response to an open-ended question is different from memorization. Memorization, when you ask, is the cat in the blank hat, that I can tell you is memorization. If you say, can you give me some ideas for the following things, and it comes up with novel, interesting ideas, that's ideation. Now, the other thing it can do that's different from just memorization is it's now solving mathematical problems. One of the issues that had to be overcome and was overcome between November of 2023 and really September of 2023, we're talking about it in that short a period of time, is the advances in quantitative solving abilities is sort of the velocity of that transformation is extraordinary. And the quantitative abilities are not just memorization. It's actually solving things that we did not understand ourselves. So the reason I say that is I think that people take comfort in memorization. They take comfort in, oh, this is not going to replace us because it's simply memorization. Or the hallucinations are, which are inaccuracies, which we'll talk about. It's a real problem. The hallucinations are just getting memorization wrong. I think it's much more complicated than that. And so if you sort of put AI in the box of memorization, it may comfort you that it can never replace judgment. But if you take it out and you say it might replace judgment, it might have judgment. It may have better judgment than some people who have really bad judgment. Right? I mean, we all know people who've got really bad judgment. And if you've got a tool who's got some good judgment, it's not just memorization. But what do you think, Bridget? I'm curious.
Yeah, I'm on the same page as you. I hope we can make this more interesting, and I'll disagree with you eventually. But I think that, I mean, I've been completely persuaded that it's doing a lot more than memorization. Idea flow is actually one of the things I use it for most, and my teams use it for most. I actually had done a organization-wide training on the practice of ideation, of idea flow, because there's a lot of really interesting data from usually design schools about how important ideation is to innovation. So I had everybody trained on idea flow, and then all of a sudden we realized GPT-4 could do it far better and far faster than we could do it. So that right there is one of the ways it makes it pretty clear. But I think that even Sam Altman said that when GPT-4...
The head of OpenAI.
Oh, sorry, the head of OpenAI. You probably followed that story in the New York Times in the fall when he was deposed for 3 days. But he said in April, when they saw GPT-4 start writing code, writing computer code, that they didn't have any idea that it was going to be able to do that. So it taught itself how to build code. And it does that pretty well. I don't know if, I mean, I don't myself code, but my IS team has been using GitHub, and it solves problems that they were not able to solve in our code pretty quickly and pretty easily. So I'm completely persuaded and on your team on this one. So we should find another way to disagree.
And let me sort of read you one little paragraph from this paper this research paper that I've been talking about, which was September 4th, 2023, which says that a significant number of functional linguistic abilities are emergent in LLMs. Okay. The emergence of such functional linguistic abilities in LLMs, especially those which cannot be based on mere memorization, has profound significance, with the potential to shape the future research directions of natural language processing. And so the paper is really, I would recommend it to you if we haven't already convinced you of that.
All right, we're getting stuck in section 1, so I think we can cover 4 and 5 together. You want to briefly explain what fine-tuned models mean and what multimodal models mean in the context of LLMs.
Yeah, and let me just sort of, can I pause on number 3, the benefits and limits?
Oh, sorry, I forgot about that one.
That's because
that one's actually really important.
That's because it's hallucinations.
Yes.
So one of the things, and maybe, I think that Mr. Lewis was talking about, every single day there's something new with generative AI. There just was a study that came out yesterday from Stanford looking at ChatGPT 3.5 and some of the ways it can get things wrong at a very high level. Now, that's a different model than ChatGPT 4 if you pay your $19.99 a month and download that version on your phone. Now, these inaccuracies are called hallucinations. Why are they not just called errors? They're not just called errors because they don't understand why the models are getting it wrong when there is what is called ground truth, meaning the real McCoy embedded in a document that the model could look at and say, oh, the population of XYZ is 3 million in the census of X, of 2020, whatever the last census was, right? So there's a ground truth, there's a real truth, but for some reason some of these models will make things up. One of the dangers of the models is that they're incredibly persuasive. They really, really, really want you to believe them, which is its own kind of weird thing. And that's what happened in the Avianca case, where the lawyer had written something and had said, are these cases? And the model said, yes, I swear to you that they're the cases. I promise you that they're the cases. And they weren't cases. Now, one could sort of talk about whether he should have checked the cases. Let's leave that to the side. The model wanted him to believe that these were real cases. So it's a kind of a bizarre kind of persuasion. So it's hallucinations. Now, these hallucinations are a real issue that a lot of computer scientists are working on today. But they're a problem in terms of rolling out these tools for prime time in our profession and in a lot of other places, right? So we've got to solve that problem. But one thing I wanted to leave you with, the other issue is confidentiality. So if you're using off of your app, ChatGPT, anything you put into it goes into the wild, right? If it's not within a system of by your office where they have like an enterprise GPT. If you're just using the plain old one that you downloaded off the internet from the App Store, your queries and the answers are going into the training of the model. So if you say, my mother, who is XYZ age old, has the following income, is there in the vicinity a place where I could get her a, sort of a facility that will have stepped care? Her information is out there now in the wild, right? And somebody could say, tell me about Ms. So-and-so. And it may hallucinate and tell you that, she's 22 years old going to NYU and majoring in dance. But there could be something else. So one of the things I wanted to do was talk to you about the ways in which there is real work being done today to solve this problem. And this, again, is new. 31st December 2023, you can download it again from archive. It's called RAG, R-A-G, Truth, a hallucination corpus for developing trustworthy retrieval, getting it, augmented, enhanced language models. So what this RAG means, R-A-G, what it means is that the models are now grounding themselves in actual documents. So the model will now say, like a Bing chat, okay, you've got a nice answer. Go out and check yourself. And so it's instructed to go out and check itself and to get retrieval augmented answers. That's one of the ways that hallucinations are coming down. Another way is called factored verification, detecting and reducing hallucination in various kinds of papers. And that's the 16th of October 2023. And the last one is just from the 8th of January 2024, and it's called A Comprehensive Study of Hallucination Mitigation Techniques in LLMs. So the point there is when people tell you these things are hallucinating all over the place, they're useless, right? Stop and remember that the commercial proposition here is that every lawyer in the world is going to use these tools like Westlaw and Lexis if they can. And there are people who are working on getting this right because that's our world. And so they're going to solve this problem. It's not solved now, but it's going to be solved. What do you
probably quickly, I think.
Yeah.
I actually don't think it's that far off. But just to put a finer point on this hallucinations problem, you've probably seen the research, I think it's Ethan Malik and his team, about if you're polite to the generally trained models, they give you better information, they hallucinate less, so be polite, which is a good lesson generally. And also, this one was fascinating.
But it's not cognitive. Do not think it knows anything, right? No, I mean, I wonder.
It's
You have to
fascinating. No,
wonder.
and this one is really fascinating. Maybe you saw this as well. Also, Ethan Mollick, if you, who's on the faculty at Wharton, is really worth following. If you don't follow his Substack, subscribe to it right now. He's, I think, the most thoughtful person talking about what's happening in this field in a way that everybody can understand. But he's also doing some really serious scholarship. They also recently ran an experiment where they started seeing more hallucinations in December than in May. So they told the large language model that it was May, and the theory was, oh, the holidays are approaching, and we're going to get a little bit lazy and a little, fast and loose with our answers. And when they told the model that it was May, it actually gave them better answers and fewer hallucinations.
Okay, that's really weird.
It's creepy.
I did not know about that.
It's a little creepy, but super fascinating. Ethan Mollick, yeah. So the
How
other
do
thing
you
is
spell Mollick?
Mollick. Literally, I read him every day. And follow him on Twitter, follow him on LinkedIn, and get his Substack. It's really a great way to sort of follow the research in bite-sized chunks, so you don't have to read the whole paper if you don't have time that day. The other thing is there are some models that hallucinate less. The models that are built on legal texts, co-counsel and Harvey, hallucinate less, but not never. I mean, Harvey actually does have a way of using it where it does not hallucinate. But co-counsel, we've had a group of panelists experimenting with co-counsel now for 9 months. We've caught it hallucinating a number of times. So it's a lot less than using GPT-4, but it's not never. So there's still work to do. Have you tried Perplexity AI yet?
No.
It's a great tool. I really like it. It supports everything it says with clickable links. So if you're really
That's
concerned,
like Bing
it's
Chat
like Bing
does
Chat
now.
does now. But Perplexity's, I find it a little bit more useful for some research projects. So and there's a free version. I'm told the enterprise version is better, but the free version is pretty good. So I recommend it.
Is that a legal tool?
It's not a legal tool.
It's just
for
a regular
general purpose
LLM.
research. Yes, yeah. But
See,
pretty,
this is why
pretty
it's
great.
good doing a panel with her.
Yeah,
And
we're going to learn a lot. Yeah.
So, one of the things I think that is so interesting about hallucinations is that you just don't know when they're going to happen, right? It can sort of...
Everything's going great.
Everything's
and then all
going
of a
great,
sudden,
and then boom.
Yeah.
But let me just give you an example of the kinds of things that these tools can do right now where the abilities of these tools are really highly functioning. So, for instance, I was prepared to do an argument in the Ninth Circuit a couple of months ago.
MCLE verification code G
Of the briefs into Harvey, and I said, "Can you please give me the questions, the most likely questions, and the answers that the panel is most likely to ask me?" And I also gave them the name of the panel because I, at that point, had the name of the 3-judge panel. And it gave me extraordinarily good questions, and it gave me answers tied to the record. And so it can do that. Now, if I'd asked a fourth-year associate to do that at a very expensive law firm, it would have taken that associate a couple of weeks to have learned the record, right? And then they probably wouldn't necessarily, they would have had then go off and read, X, Y, or Z judges' decisions to get a sense as to how they thought and what kinds of questions they were likely to ask. And the large language model really did it fast. Now, I did another one where I said, I want every case that Judge X has written on this topic. It was about a settlement release. And it gave me exactly the cases that I wanted. I was so excited. I was like, oh my God, it's Saturday morning and I'm going to be done, right? What's that?
No, I was going to say, similar story. I talked to a solo practitioner, so he didn't have any associates, and he didn't even have any time to figure out who could help moot him for an appellate argument. Didn't do very many of them. It was in a state appellate court. He did know the panel. He gave them the publicly available documents, asked the LLM to ask him questions as if it were the panel, and he answered them. And then he asked the LLM for a ruling, and it wrote a ruling, and it ruled against him. And he then asked, what could I have argued, what responses could I have given that would have led to a different result? And it gave him a bunch of advice. Yeah, do it next time, right? Yeah. It gave him a bunch of advice. He took the advice, he used it, he won the case.
Oh, wow. Okay, that actually, these are efficiencies. These are true efficiencies.
Yeah.
And, but it also goes to the next panel where the transformative nature of this technology should not be underestimated. But in this exciting moment, when I was like, I had asked this, I asked Harvey, give me the cases relating to these releases. It wasn't particularly complicated, and it gave me cases, it gave me cites, it gave me parentheticals all of which were different. It described the case, everything, it had a whole world it had built up. Not a single one of the cases stood for the proposition. Actually, the sites led to a case. None of them were by the judge I wanted. It was like Judge X, Judge Y, Judge Z. My judge was the one that I wanted, was nowhere near there. And so it just hallucinated, but in the strangest way. It knew what I wanted. It sort of developed it. It was very persuasive. It made me happy, just for a brief moment. So anyway, we're on to fine-tuned models.
Yeah, so fine-tuned models and multimodal models, just you quickly want to describe what that means?
Yeah, so fine-tuned models are, right now we've described LLMs. That's like the chat GPTs of the world. That's like the base model, right? So on top of those models are all of the specialized models that are called fine-tuned models that deal with particular industry use cases. And they can be extraordinarily good and extraordinarily powerful, because when you fine-tune a model, you reduce, you don't eliminate yet, you reduce the hallucinations and you make it much more geared towards solving a particular issue that a company might have. So for instance, you might have a base LLM that is being used in the pharmaceutical industry for drug discovery. What can it do? It can actually be fine-tuned with all of its research on top of it in another LLM. Think of it like Lego bricks. The base ChatGPT is the bottom Lego brick. On top of that is the Lego brick that is the fine-tuned model, right? And that fine-tuned model may have all of the academic work of that particular company, as well as academic papers relating to the pharmaceutical industry. What does it do? We are already seeing the first patent applications for drug discovery. It can come up with new molecular combinations that no one had thought of. But not only that, it can come up with predictions of toxicity that might have taken human beings being part of a drug trial to have come up with. And so the power of these fine-tuned models is extraordinary. Harvey, which is a legal tool, is a fine-tuned model, fine-tuned on the legal data set. Co-counsel is a fine-tuned model. It can write cross-examination, deposition questions. All you have to do is upload some documents. It can write briefs for you. It can write a complaint. You can upload a public complaint and say, give me the best arguments for a motion to dismiss. I spoke to in-house counsel. They say they use them now when you're doing an RFP, right? When I got off the bench, I realized that somehow RFPs had become the whole world, like somewhere in there, like I was Rip Van Winkle, they had become like the whole world. But anyway, RFPs do rule the world. And the in-house counsel are using them to say, well, when you talk to me about this new case, and I'm wondering what are your arguments for the case, one thing they may have gotten is a head start. That's a fine-tuned model. Multimodal?
Multimodal models are models that are trained not just on text, but on other data. So multimodal models can train on audio, they can train on video, they can train on images, and they can learn from different kinds of data to be able to produce the work that they produce in response to your questions. They're pretty stunning, I think.
They're absolutely stunning.
Yeah.
Yeah, I have an article coming out in the New York Law Journal, I think it's this week, on multimodal models, but I call it When AI Opened Its Eyes.
Yeah.
And if you look at a paper from Archive, you'll be able to see, these are all by researchers. Archive is just a collection, right? These are by researchers from academic institutions. But there's a paper that's dated September 30th, 2023, and so I read it on October 4th. And I was absolutely blown away because it's really, and then you can look, I have another one. I've got another show and tell here. GPT-4V. GPT-4V, which is GPT-4, ChatGPT 3.5 is what you've got on your phone. GPT-4 you can pay for. GPT-4V, the system card, you can get on the internet, just search it right now, you can get it on your phone, and it will tell you about multimodal models. It's about vision, GPT-4 with vision. What does it do? It is a baby opening its eyes. So you can tell that an elephant can't fly, not only because you're told that an elephant can't fly, but because the elephant does not have wings. The elephant is big and huge and looks like it's a land animal. So the ability for these multimodal models, which are now just coming out, we are at the beginning of these, right? That what these are doing is they are measuring and able to take in data in ways that people had never imagined before. So when you're ingesting that data through that pipe, you're ingesting not just words now, you're ingesting measurements, you're ingesting the audio. Every single digital photograph, even if it's a still photograph, if it's digital, behind that photograph is an audio file, which can get lifted off. And all of that helps train this model. You can now look at thermal data relating to a fire, and you can measure different things, and you can measure depths. Anyway, it's extraordinary.
And I think it's going to be the next big moment in this marketplace. Alphabet's new model, I think, coming out soon, any minute now.
It's out. You can get
multimodal.
Yeah, you can get now. You can take a look at the Gemini.
You can get Gemini?
Yes, you can get it on and through Bard also. You can get it through the through your browser. Go into Bard AI app and you'll get part of the Gemini model, which is the Google model, and it can produce for you charts. And you can say, give me a chart of the stock price of X company, and it will draw you now a chart.
You can feed it a data set and ask it to run regressions on the data set and make a chart from those regressions, and it will do it. Yeah.
But the one issue is, can you check it? It's getting so far ahead of us, right? And this is like you're, using the GitHub Copilot. By the way, if you feel like you've heard the word Copilot a million times used in a million different ways, you are right. Okay? I don't know if there's a trademark case to be had off of this, but GitHub Copilot was the original Copilot that is the repository of the code that is used by a lot of folks to generate code. Microsoft Copilot is a totally different tool, although I think they've invested and maybe even bought GitHub Copilot.
I think they did.
Yeah, they've done it all together.
Yeah.
Okay, so Microsoft Copilot is the 365 suite. It's your Office, it's your PowerPoint, it's the Excel, all of which has generative AI embedded in it once you upgrade, but you'll pay an additional price per seat.
And then there's Co-Counsel, which is related, sort of, but that's a separate product. But all right, we're going to move on. So we're going to talk a little bit, it's already 2 o'clock, and we were going to take questions in 15 minutes, so we're going to really start speaking quickly, which I can do.
Well, what we wanted to really do also here is, and we've previewed a lot of this, which is the sign of a good talk, which is you preview things and then you reinforce things, and then we will emphasize them during the Q&A, is that we've already told you a lot about what's transformative about generative AI, that it is so different from other technological advancements because of the breadth of the utility and the ability right now to exceed humans. Let's go back to this chart. What this chart tells you, do not underestimate this chart. You can get this chart in this paper that I brought for us to look at. You can get it on Archive, and you can also get it on the OpenAI website. It's called Sparks of Artificial General Intelligence Early Experiments with GPT-4, and it will show you all of the tests that GPT-4 has been able to pass. That's the blue line. The AP classes, it's able to pass the medical boards, it's able to pass the bar, it's able to pass final exams, it's able to pass BC calculus, and it's never been trained in any of this, all right? So the transformative ability of this is just extraordinary. So as basically the CEO of DeepMind has said, which is one of the big AI companies, and of course we've got lots of folks. Elon Musk is right up there. Bill Gates is right up there. Stephen Hawking, before he passed, was up there. We've got, of course, Altman. Many people are, believe that this quote would be accurate. We're not messing around. They really believe that artificial general intelligence is possible. But who knows when it's going to come? The timescales are debatable. And we need to use now We need to use this downtime when things aren't yet hysterical, although there's a little hysteria, to prepare for when things get serious in the decades to come. It's not going to be decades, by the way.
No.
And then the time we have
explain
is
what
valuable.
artificial general intelligence is briefly?
Yeah, why don't you do that?
So artificial general intelligence is when the computers can do any task that you ask better than humans can. That's not where we are yet. I don't think anybody would say we're there today. I think everybody thought we might have been a couple of months ago.
Can you pass the board, the medical board, in one shot?
I think it can beat me on almost everything. Yeah.
But I think that you're, smarter than the average, yeah.
But it is definitely the case that there are still areas where humans are ahead of it. I know my daughter's doing a PhD in econ at Yale, and it's all math. And so far, LLMs are not that helpful to her. I think that won't be true in a very short amount of time, but there are definitely tasks it's still not quite ahead of humans at.
Okay, so if you're getting a Yale PhD in economics, you're safe.
Yes.
But the rest of us
For
mere
now.
mortals may be just lost.
For now. Yeah. But I think that the varying predictions on when AGI arrives are super interesting, right? I've heard people who know a lot more about it than I do say they think it could be here in just a handful of years. And I don't think anybody predicts that it's much later than 2 decades. Is that about?
Yeah, so, this is one of the things that you can get from some of the books that we've mentioned. There's also Ray Kurzweil, who's written a book called Superintelligence. I also recommend that. If you are already familiar with some of the other books, Ray Kurzweil has written a number of books, and Superintelligence is a really tremendously interesting book, and he's just a great thinker. But that book really does do a whole analysis of when AGI can come into being. Let me add to your AGI.
Yeah.
It used to be, and when I say used to be, 5 years ago, it used to be that people thought AGI was the moment when computers or artificial intelligence would meet and exceed humans, and we'd be off to the races and they would rule the world. And then AI started to get really, really smart. And they said, oh, JK, just kidding. AGI is only cognitive ability. It's not sentience. Sentience is situational awareness, a kind of substantive awareness of where you are, who you are, what your surrounding is, a sense of your place in the world. And so AGI became combined with different kinds of theories of consciousness to come together. So we're moving away from the concept of AGI being sentience. So most people today would say AGI is about cognitive capabilities. And I would say, based upon the studies right now, that AGI is someplace, in my view, I'm actually a hawk on this. I mean, I think it's in the next 3 to 5 years.
I do too.
They've got, right now, OpenAI is training AI 5, OpenAI 5.0. We know from the board fight, that's just my opinion, that there's something very special in it.
Oh yeah, that little leak was fun. Yeah.
It was fun. Something was happening.
Yeah.
Okay, what are the challenges to adopting all this? What are we going to be seeing? Well, frankly, humans, we in this audience, we are the problem to adoption, and maybe we're the solution to adoption. Maybe our being unable to keep up is going to be a good thing, but the ability of these tools to do things that are extraordinary is going to exceed our ability to keep up. So we're going to have lawyer personality as our culture, not enough time to really learn them. We don't really know how to use these things. There's no roadmap. We don't have the right talent to teach us how to use these things. Prompt engineering, learning how to talk to these machines, how to get the questions right, is its whole thing.
They don't come with any manuals. There's
no
nobody
manuals.
you have to actually just try and figure it out yourself. That's not usually how you learn new technology, right?
Right,
Usually
right.
you have a manual to teach you. No such thing.
No such thing. And so we've got some key concepts that are discussed all the time. Safety, transparency, explainability, reliability or robustness, fairness and accuracy. Which ones of these, Bridget, are hitting your radar screen, and which ones are you most concerned about?
So those are really different questions. I will say that the concern that is raised to me most frequently from people in the legal profession is a view that because these models are trained on data that was created by humans, and humans are flawed and humans are biased, that there is bias in the models that will be replicated and sort of calcified in terms of the profession. And that's the one that's raised to me most often. I will tell you that I don't share that view. I believe it's a lot easier to debias a data set than it is to debias a human being. If you follow the literature on judges' decision-making before and after lunch, before and after an election, you will quickly agree that debiasing a human is super complicated, but debiasing a data set is actually something technologists are now working on. What is the thing you worry about the most?
You know, I think that we're going to see the fairness accuracy point, I think, is a really big point, which is you can have a model that's working accurately. It's whizzing and whirring around all the data, and it can be doing that correctly. The algorithm and the data, it's doing it accurately, but it could lead to an unfair result. So let's just give you an example. Assume for the moment that you're using, and there are all kinds of tools. One of my books called When Machines Can Be Judge, Jury, and Executioner does this. It goes through all of the kinds of tools that are out there for criminal justice all over the country, and they're used in every state. And one of the things that you learn is that when you're using a data set to talk about potential recidivism, to talk about potential violence, and you're using it for a variety of purposes. Where should somebody be housed? Can make a huge difference in terms of their access to programs. How long should they be sentenced? What kinds of programs should they get, either while in or when out? Should they get bail, real liberty determinations? When you're looking at those questions and you're basing it on a data set that is old, perhaps includes things that aren't even crimes anymore, like cannabis crimes, perhaps occurred during a time when policing policies were different, maybe during a time when there was an over-arrest of black men between the ages of 18 and 34, your data set is biased. And so again, patterns, patterns, patterns. What rises to the top is going to be a sense that that's where the recidivism is, that that's where the violence is, and it may no longer be reflective of our values in society, of what we believe is fair, of what we would do today, of the crimes that we consider to be crimes today. They may be cannabis in many places is no longer a crime. So these things, I think, the fairness versus accuracy are incredibly important. The other one I think that's important is, frankly, transparency. We just don't know how some of these things work.
Yeah, and you know, that's also true about some judges' neural networks, right? We don't know exactly how that works either always, with all due respect to my people. All right, we got to try and catch up. How will the law catch up? Oh, this is you.
All right, so one of the things that we have when we're thinking about how the law is going to catch up is, what do we do now that we've got these tools that are both coming and are already here? We've got the existing narrow tools, and then we've got the tools that are to come. So what do you think the courts are going to struggle with most?
I've been doing a lot of presenting on this topic to courts, to judges, to court administrators, court managers, and I feel for courts. They rely on public funding, so they don't always have the most advanced IS teams in the business. It's really hard for them to attract talent. As somebody who tried to hire talent into my IS team for a long time, it's hard to hire talented technologists at a state court salary. And they have to, at least state courts, you had the lucky benefit of being on a federal court, but in state courts, politics makes things very complicated. So I think this is going to be a really complicated time for courts. State courts are overwhelmed already. In Michigan, just for one example, the Michigan courts adjudicate between 3 and 4 million cases a year. In every state in the country, 92% of people don't have access to lawyers to help with their civil justice problems. And that, you see that in state courts. State courts are trying to manage issues that are really important to people without the help of lawyers on most of those cases. This technology, I think has tremendous upsides for users, for court users. I think it has the possibility to democratize legal information in a way that, amen, I say, and give people some resources to understand what the law requires of them and what it provides for them. But you could imagine courts being quickly overwhelmed by any legal startup that figured out how to file thousands of debt collection actions, for example. The courts are not going to have the technology to figure out what's real and what's not. Deepfakes are an enormous problem for courts. There is right now, there is technology that is ahead of all of the safety tools. You can create deepfakes right now of me speaking that would be completely believable, and there would be no way for a technology to sort that out. That's going to be a really big problem for courts. As we know, very few cases actually go to trial. Most cases are adjudicated before there is fact-finding, but in the cases where there is fact-finding, it's an enormous problem for courts. Okay.
Well, just on the deepfake point, let me just make one point, which is, what happens when our jurors stop believing in the evidence, right? And they start to second guess. So if you can't look at the video and go to the tape and see the video and try to analyze the video, and you start to distrust that, and the experts, maybe you don't even have, it's a battle of the experts, but right now you can have metadata, you can have that underlying digital data that will tell you that it's real and it's fake. So what happens when the audio tape, when the wire, when you put somebody at the scene of a crime, you take somebody away from the scene of a crime, and then you end up with a plea, maybe, that was based upon somebody believing, I'm never going to get away from this. I didn't do it, but there I am. I'm placed at the scene of a crime. There's a video of me. I know for sure I wasn't there. Are you going to end up with a different sort of scenario? I don't know. I think it's very, very troubling overall. So let's prepare. We're going to prepare ourselves. And I think this is you.
Yeah, I'm going to skip right through the questions. I might go back to them if that's okay.
Yeah.
Yeah. I mean, I always say that the business of law, the practice of law, and the democratization of legal information are all going to change dramatically and quickly. And so I think leaders of any organization, or just if you're running your own practice, you're the leader of your own organization, should be focused now on planning for what this looks like. I always tell courts and other organizations that you have to throw your old strategic planning methods out the door. You no longer don't have the ability to plan 5 years from now. It's not going to work. You can write a strategic plan for the next year, but you're going to be revisiting it every 3 months, and you're going to be making changes to it every 3 months. Strategic planning is going to be very, very different than it used to be. You have to be ready to be radically open to changing your plan quickly. I believe that every organization should immediately build a team that explores the threats and opportunities both to your internal ops and to the services and products you provide to the market. Map those out. Try and figure out, where is it a threat? Where is it an opportunity? Where can it make a difference in how we operate internally? What is it going to do to the products and services? And then right away, start that radical optionality planning for what that looks like. I can give a whole talk on this topic too, but I believe that it is going to make all of your internal operations better, faster, more effective, and therefore cheaper for your users. And if you're not doing it, the guy in the office down the hall is going to be doing it. So it's something that everybody's going to have to pay attention to.
What about the billable hour?
Well, I mean, I've been predicting the death of the billable hour for a very long time, because it doesn't make any sense. But if this doesn't kill the billable hour, then I guess it's here forever. But I think it kills the billable hour.
Yeah, I think it kills the billable hour too.
Yeah.
And why? Because when these tools are good and reliable, and that's going to be in the next 18 months or so, right? It's going to be that soon, because that's how much money is being spent on these tools. You're going to be able to do things incredibly fast, and in-house counsel will be able to do them incredibly fast too. So there will be a payment for judgment, but it's going to be a different model. So the number of young associates that are going to be needed is going to be very different. It's going to be the pyramid that was like this, that gave leverage and made people a lot of money, is going to change. And there's not going to be an elimination of the need for lawyers, but our job is going to change fundamentally.
Yeah, and some in-house teams are already doing this. I have a slide in a different deck that I use. That's the letter that the General Counsel of Ford Motor Company sent to all the law firms they paid over $1 million to last year. He happens to be my husband, so I have access to it. Saying Ford was in the co-counsel beta, so they have an ops team that's been using it for a long time. They said, tell us why we should be paying you anymore. Tell us how you're using this technology. Tell us how it's going to come in, how our bills are going to look different as a result of it, as we decide who we're going to use next year. So some in-house teams are already making these changes, and law firms, some of them are yours, are focused on what does that mean for us. But if yours isn't, I think now's a good time to get focused on.
Yeah, I mean, my firm has a whole initiative on looking at head counts, floor space, footprint, hiring practices, billing practices, training practices, and all of that, because it will be not changed next year, but in the near future. So we're just down to the future. We got like 2 minutes each for the future, and then we'll open it up to questions. What do you think the future is going to hold?
I think anybody who thinks they understand what the future is going to hold is selling you a bill of goods. I will tell you that I do reading on this, as you know, every day now. There are 2 podcasts I listen to every week. The Hard Fork podcast, the New York Times Tech podcast. It's great to just keep up with what's changing week to week. And the Marketing AI podcast, it's misnamed. It's not really about marketing, but those guys are doing...
And I have one coming out.
Oh, good.
Yeah, but I'm running into trademark issues with every name that I want, so I don't even know the name. Just look for Forrest.
I have
it'll
one
launch
coming out
this
too.
month.
Mine's called the AAAI podcast.
AAAI?
Yeah.
Oh, that's good.
Yeah. I have a AAAI lab, so...
Oh, yeah. Okay.
Yeah.
When are you launching?
At Legal Week next week. We have a big presentation at Legal Week. So yeah, that's when we launch. But I think that I've said it a few times, I think the business of law, the practice of law are in for dramatic change. I also think there's a tremendous upside potential for solving what I view as a massive market failure, the civil justice crisis in America. That 92% of our neighbors can't get help with the legal problems that really affect their lives, housing, family, is shameful, frankly. And I see tremendous upside potential in this technology for making a difference, finally, in access to justice.
And I see access to justice as a huge positive as well. I think that we have to overcome the flaws in the free technology so that we don't have an us-them, where the people that have access to justice have access to the tools that are hallucinating the most, right? We don't need to do that. We don't need to make their problems worse. You're better off with a poorly written story that sticks to the facts than you are to a hallucination that actually makes it a whole lot better. But I do believe that when the tools get better, the ability to actually have people be able to tell their story and have a complaint written for them and to start to even that playing field is enormous. I think that what the future holds, I agree. I think it's a little unknown. We are at, as I've said to some audiences, the beginning of the beginning of the beginning. We are at a point when we really don't know in 5 years what our world is going to look like, with one exception. It is not going to look like it looks today. That I can absolutely assure you. The kinds of conversations we will be having in 5 years will be incredibly different. So I wanted to tell you about one more paper. It's called MAMBA, M-A-M-B-A. It's going to sound fancy, but it's called Linear Time Sequence Modeling and Selective State Spaces, and it was just published, okay? It was just published last week, 2 weeks ago. The point of MAMBA is that it is a different technology from GPT, but does the same thing as large language models without the hallucination and with lower computing power.
Far less compute, I think.
Far less compute.
Yeah.
And so I don't know if this is going to be one of the new answers, but what I do know is that something like this is going to reduce costs, solve some of the issues with hallucinations, and take us into a new era. Questions, folks? Who's got one?
There we go.
Yes.
Hi. This was really fascinating, much more fascinating than I thought for a dinosaur to listen to. But you didn't touch on one aspect that I'm very interested in, and that is the work that was done by Tversky and Kahneman about thinking fast and thinking slow, and whether or not AI imitates one or the other. And more importantly, they found that in order to solve problems, you had to sometimes think fast, or at least understand how people think fast in order to solve those problems. And I wonder if either of you have had any thoughts about that.
So did you know
Go
that
ahead,
book?
go ahead.
So I love that book. I love Dan Kahneman's work generally, but Thinking Fast and Slow is has been a book I've used in a lot of different contexts over the course of my career, and especially in forensic science. A lot of mistakes that get made in law are attributed to the fast thinking that our brains have to do to save us from car accidents and all the other things that our fast thinking does. But I've actually seen some research on this recently, and of course I'm not going to remember now what it said, but I think that there are technologists who are trying to sort out how to make sure large language models can do both. And I predict that they will do both pretty quickly. Have you followed this research? It's super interesting.
I haven't, and I've just written this down, and I now am going to take a look for it. So you folks are both ahead of me on this.
It's a super interesting topic, yeah. I think you're going to see a lot more on it.
Hello, my name is Lin Fei Wu. I'm the CEO of the In-Time AI. We are very honored to sponsor this event. So I have a question regarding the price. So GPT-3 is GPT 3.5 and GPT-4, although GPT-4 is very powerful, but it's also very expensive. And I know that right now only some big law firms have ability to afford that cost. But how about a majority of the middle-sized and small-sized law firms? So what kind of AI product we can provide to them?
In terms of the cost, the overall cost, I think that we're going to have a situation where right now Lexis and Westlaw are extremely expensive, and they are, for instance, tools that are being relied upon by law firms, and the government gets it for free, but law firms don't, and academic institutions have their own arrangements. So I think that my view is the costs are going to have to come down, and that they're going to want to, OpenAI is going to, I hope, bring the price of the $19.99 down or eliminate 3.5 because it's going to have a reputational harm. That's what I hope. I don't, I think OpenAI has done a phenomenal job in many of its tools, but it is expensive to get the good tools right now. Is that responsive to your question?
Yeah, that's also one question. Yeah, so just one small advertisement. So we built this enterprise co-pilot for legal professionals, and our price starting from $49 a month. Yeah.
I think the co-pilot, this is a real issue. I'm teaching, I taught last semester, I'm teaching this semester a class on generative technologies at Penn Law School, and I wanted my students to be able to have co-counsel licenses to be able to play with the technology that was specifically built on legal text. It felt like that would be helpful. I also wanted to get them GPT-4 licenses, which $20 a month is more doable, but we could not figure out how to get either the VLEX tool or the co-counsel tool to university students yet. So it's because the compute power is so expensive that there is a pricing problem right now with getting these models into the hands of everybody who might want them or need them. So I think the market figures this out eventually, and probably these new technologies that use less compute are going to be part of the solution, but it is right now still a problem. I have a board member who's at TR. I thought I could figure this out, and I have not been able to figure it out. So it's an ongoing issue.
Okay, I think this is time for our last question.
Okay, well, hopefully it'll be a goodie. So my daughter is applying to law school to start in September. I mean, what the heck is she going to be doing?
Never tell her the truth. That's what I do. I've got a child who might go to law school too. Never tell them the truth.
Well, I don't know what the truth is. What the heck?
No,
what
I
type
think
of
it's a
things
super
are they
exciting
gonna be
time.
doing?
No. I actually, in all seriousness, you teach students, and I teach a class on quantitative methods at NYU. My view is for the law students who are really interested, not just the ones who couldn't do math and ended up not being a doctor, right? But the ones who really are interested, there's going to be a market for them, and they're going to learn how to use these technologies. And that's going to be part of their training. And they're going to learn how to use them, how to use the prompts, just like they do e-discovery, where they're no longer going through the boxes like I have to do. They're going to be pushing the buttons. It's all so much more efficient. So you're going to need fewer of them, but you're not going to eliminate the need for some of them. So your daughter, if she, is interested and enthusiastic and sort of embraces the tools, she's going to have a job. What do you think?
I actually think it's the most exciting time to be going to law school. I think that these technologies are going to change the practice of law, obviously fundamentally, but I think for the better. You're going to be able to do the human tasks and outsource or insource or eliminate or automate the tasks that really make law practice less fun. I also think that the generational shift is going to give people like your daughter an advantage. She can jump in with both feet and learn the technologies and be a real asset to a law practice that might have a harder time learning the ways in which they should be using the technology. I think it's a really interesting moment for students who are willing to learn and be an asset to a lot of law firms that are going to need those assets. So I think it's an exciting time to go to law school.
But we're going to need many fewer of them.
Well, that's probably right.
That's my view.
Or maybe the market changes and we have these massive cases that right now get no help where people can get help.
Maybe so.
I think there's some interesting
But then the economics change.
Yes, that's right.
All right, that's it. We're done.
All right.
All right. Thank you. Thank you very much.
Thank you.
So I'd like to first of all say thank you to Judge McCormick and Judge Forrest. I started out saying, I'm really going to have to learn something about AI. And after your talk, I want to learn something about AI. This is a wonderful presentation. I really appreciate your joining us. And next, we have a group of our members who are going to come up here and dazzle us some more.
Thank you. Welcome to panel 2. As the judges have already prescribed for you and described in great detail, we are now at our Promethean moment. This is when we're actually going to start telling you, this is what you can do with the tools. This is probably, hopefully, going to be the most practical element of your afternoon, because we're going to describe not the horrors, although we do have to talk about Matt Avianca, but we want to tell you about what the future is actually going to hold. What are you going to be doing with all of these tools? How many different use cases do we think, as us, as I dare say, the 22nd century lawyers, what are we going to be doing with all of these generative AI tools and anything that might evolve from there? I'm very happy that President Lewis was able to introduce my 3 distinguished panelists, because when I chat GBT'd them, they are not famous or infamous enough to be inside the tool. So we're talking about a new era here where you'll probably be able to do some research on your co-pilots when you're doing programs like this. So what do I want to talk about? What are some of the legal use cases? We presented here crumbs of where you could go with them. But I'm going to turn it over to some of my panelists who are actually using some of the technology for contract analysis, document drafting, predictive analytics, data analytics and research, and just simple chatbots and virtual assistants within a law firm or other legal practice. Can I start with you, Ignatius, and talk about, of any of these 6, how are you leveraging these tools?
So, yeah, I mean, I think it's, some of these tools have been out here to a certain extent, but as the earlier panel discussed, I mean, really it's kind of developed in the last year with ChatGPT, generative AI, and it really, especially in the legal industry, is enabling a lot of different uses that are in some ways still being thought of, still being applied. So it really is kind of the time where these tools are being developed, figuring out what ChatGPT itself can do, what questions you can ask. Just to go through a couple of these, contract analysis, you used to have piles of contracts, and you try to figure out, what are kind of common clauses, which ones you mean certain things, have certain termination clauses. It's become a lot easier, with ChatGPT to interpret contracts, to go through large volumes, to categorize them, find key terms and provisions. So that's one use. It's probably more in the in-house, corporate side of things. Document drafting. This, it really affects all facets of the legal profession, from transactional to drafting documents, where you could potentially use a tool to help with transactional documents, based on a prior version, perhaps, that may have taken days earlier and now might take minutes or a very short period of time to draft a document, draft a contract. Legal briefs, be part of document drafting. At the prior panel talked a little bit about that, the Avianca case. I think that the moral here is you have to know how you're using these tools, how you're using ChatGPT. In that case, mistakes were made, and they did not check the cases, and filed a brief that had fake cases. That's not the way you should be using these tools, as and these tools are changing, as the prior panelists mentioned, to become more effective, to have fewer hallucinations. But part of it as attorneys now is knowing how to make use of these tools, what questions to be asking, perhaps having in place policies at your firms with regard to the use of this technology. You want to know who's using what. It should really be firm sponsored, approved, when you're getting into really any of these uses of generative AI.
Would you say, Ignatius, that before deploying any of these particular use cases, that the firm or the in-house attorney set should have developed some type of AI-related policy?
Yes, I think that's an area where I think if everyone in this room can kind of think about that for your firm, even if you're a small firm, if you have associates that may be going out to draft a brief, they need to have guidance, or they may make a mistake in how the information they put into a tool. We'll get into closed models and kind of ways to protect the data that you're putting in. But as attorneys, one of the most important things that we have to worry about is the confidentiality of our clients' data. So, having a policy that helps to regulate that is really important. You don't want to dissuade, not encourage the use, but you need to understand how your firm is using it. Perhaps have approved tools. We're talking about Westlaw, Lexis, that are kind of rolling out AI as a part of their product. There are other tools that have been talked about. It may be that your firm says, okay, this tool can be used, but within these parameters. Perhaps you have clients that don't want you to use certain tools. It does get a little complicated, and you have to think about how your firm is utilizing all this technology.
What would you say is primary, Marissa, at CUNY for any of these use cases, or are they a little different?
What I would say is, just looking at this list, the tasks that are better suited for AI, to me, represent tasks that are repetitive in nature or based on factors that can be learned through repetition or data analysis. So very much data-driven when I take a look at this list. I think of first-level documents, templates that you may create without any identifiable information. So it's basic information, basic letter drafting, basic documents, basic legal research. All of these are a good place to start in terms of law. However, we have to keep in mind what the other panelists had mentioned and what we know from case law now is the concept of hallucination. So any output, any product done by any of these use cases, anything that's generated has to be verified. So you're getting this output, you're getting this information, but you have to make sure as to its accuracy, as to its veracity.
I actually have a quick question for the audience, maybe
Sure.
by a show of hands. How many of you have used either a version of ChatGPT or a similar tool, similar generative AI tool, not necessarily in your legal practice, but in some way? Okay, about close to half. One thing I recommend, is you can go to openai.com and create an account and use it. It's free. The ChatGPT 3.5 is free. 4.0 you have to, I think it's $20
Yes,
a
with
month.
the huge disclaimer right at the bottom now, thank you, Avianca, that you have to affirm the accuracy of whatever it is you're getting out of the tool. But more importantly, this is your opportunity for free to do experimentation on different types of input or queries into the system. I don't care if your query is, I want to make banana bread, how do I do that without bananas? If it gives you an answer to that question, please let me know, because that's not something that would sound like it would be real, but you never know. Ron, in your experience, being former magistrate judge as well, are you concerned about the development immediately or adoption of any of these particular use cases?
No, because frankly, judges would not see any of this until there's a problem that arises and it's brought into litigation. I'm being blunt about it, but I could easily see a situation where some language is taken from something that might be copyrighted, for example, and used by someone else. I can see some IP issues arising out of that. And I think the other issue arises out of what Ignatius talked about before, is what happens when the tool gives you something that's wrong or that really doesn't exist. And as a judge, I would have to hear the parties fight about where it came from and the like. And magistrate judges spend a lot of their lives doing discovery. And I would expect there would be a number of issues arising out of a tool when one party wants discovery of another one.
So Ignatius, take us through this particular use case from ChatGPT. You have a prompt and some responses there. We apologize that it's very small, but ChatGPT writes in like 10-point font. So this is just excerpts we're sharing with you. Ignatius?
Yeah, and this is what I was talking about earlier is, you don't want to put in client confidential information into the tool, but, you want to have a prompt that gets at, kind of communicates what you're trying to get out of the tool. And I think that, wrote draft a deposition outline for a construction expert testifying regarding construction delays. That's a very broad prompt, but you can see just by that prompt, there was nothing additional, and this was not even the more advanced ChatGPT, but, it came up with questions. I've spoken to attorneys that have used it to help begin a deposition outline, and they've told me that it is helpful, that it has come up with questions they did not think about or they wouldn't have thought of. Is it the only thing you would use for your deposition outline? No. You're not going to have it write your deposition outline and go do your deposition. But it's a tool. It's now a tool to help create that framework to maybe, again, think of questions that you didn't think of. We'll get to other ways where it could be perhaps looking at data from, or filings from your case. This is just looking at kind of the general corpus out there. I think what we've learned, it was talked about in the earlier panel, it's developing at an incredible pace. So, within a couple of years, who knows what it will be able to do with regard to deposition outline or help with a first draft of a brief. But even now, I think it is pretty incredible how it can assist in the practice of law.
So let's talk about them. You heard the first panel mention, and we have alluded to as well, this concept of a closed large language model. So effectively, not any of these open ChatGPT, open AI issues that are plaguing the nation here. But what exactly would be a closed one, Ron? And can you give us a few pros and cons of using one?
Well, let's start with open ones. Open ones you've heard about before. A lot of data goes into a training set, and the data is scraped off the internet, among other ways to get it. if you're at a law firm and you're asking questions of one of these open platforms, you're giving information to the platform that might be taken and used by someone else, or might be available. Turning the information over may itself be a waiver of privilege or work product protection. It also may be a loss of confidential information of yours or your clients. So the open models, I think the first issue is, what is the model? What's going into the model? What rights do you have as against the model to limit disclosure or the like? Closed systems, firms, corporations, whatever, that can do it are creating their internal models. They're closed, more or less. They're feeding data into something that, at least in theory, is only going to be seen within an organization. It's not going to be available to others. We can leave aside the security aspects of all that for another day. But I think the main difference is who gets to look at the model and what data goes in, and then what's used with the model. And closed models, I would assume you don't give the data out to anyone else, although, again, going back to litigation, if you're using a closed model to do something, it's possible that that might become the subject of discovery or litigation someday. So that, I think that they both carry risks, they both carry benefits. The large models probably have more data that goes into the model.
But we're talking about something that's now limited and restrictive. As you heard from our experts in the first panel, the whole point of this is to have this vast amount of data over which it can overlay a lot of information. If you're just using it for the insular purpose of making sure everything stays within the four walls of your law firm or your corporation, doesn't that render this potential large language model not as adaptive and flexible, or not producing as good of results as in an open one?
Yes and no, but then again, you get the benefit of not having your data or your client's data going out, possibly used by others. And the other problem is, depending on the open model, you're transmitting information over the cloud somewhere. And I think we all know the greatest vulnerabilities when you're transmitting information is in the process of transmission. We've seen a lot of issues with data breach and the like coming from that. So if I was using that technology, part of my ethical obligations would be to know where it is, where it's going, how it's getting there, and what protections there are wherever it is. Because the platform you're using may not be in-house. It may be located 1,000 miles away.
Good point. Are there any actual users of a closed system within your organization now that you would raise by hand? Yes, sir. And are you finding that there is a lot of efficacy in being able to use that closed model, a lot of trust and security, or is it subject to some of the same limitations or risks if you just used ChatGPT 4.0?
I think a lot of us have access to enterprise systems which are powered by Bing. I don't know how they work. I don't think they're limited to just the material of the organization.
I see. Now, so a true closed environment would only limit its data to the particular organization, and in a law firm's case, to, I assume, all of its clients, which also begs another question, and I want to turn to you to start talking about the ethical implications, Marissa. So we spent a lot of time trying to get you all competent, and if you could speak some more about the competence level. I think about a third of the room raised their hand. I think if I asked, is anyone using it to set up its movie and song playlist, I would get a show of probably 90% of the room. But once we start talking about moving this into an actual corporate environment for which death of the billable hour, but that you're billing for, all of a sudden hands will drop in the room because there's not that level of comfort, and maybe a lot of it is not that level of competence. Marissa?
So far we've discussed ways in which attorneys, paralegals, legal assistants, and the legal staff can use generative AI in law practice, and also the types of platforms, whether opened or closed. But as Vivian stated, as like any new technologies that we choose to use, or any technologies at all, we need to understand its benefits as well as its limitations, and also in order to utilize this tool in an ethical manner to improve our decision-making as well as to enhance our practice. When I think about the first panel's presentation, I think of the creative nature of utilizing systems like this, and I liken them to the fun parent panelist. And now I feel I'm going to be the rule-based, no fun parent panelist explaining the ethical rules. I think maybe perhaps, as they do in the medical profession, we need kind of a catchphrase, something that'll take off, something like, first do no harm. So maybe that's a good way to begin. So we're taking a look at the 4 C's: competency, confidentiality, conflicts, and client consent. So Rule 1.1 of the New York Rules of Professional Conduct require that a lawyer provide competent representation to a client. And it describes under prongs A and B what exactly that means. There's also a comment to Rule 1.1 that asserts that keeping abreast of the benefits and risks associated with technology the lawyer uses to provide services to clients, and that's the element of competency. So when we analyze the rule, when utilizing generative AI tools such as ChatGPT, attorneys need to be knowledgeable about the technology they're using or ask for assistance from another attorney or even perhaps the IT personnel. And if none of these options are possible, then the attorney should not utilize such tools until they're competent to do so per the duty of competency. It's possible, as we've heard and know, that generative AI outputs can include information that's false, inaccurate, or possibly biased. So competency is our duty and our responsibility, and it kind of dovetails with confidentiality. I view it as 2 sides of the same coin, because how can you maintain client confidences if you're not competent with the technology that you're utilizing? So confidentiality, Rule 1.6 of the Rules of Procedure, a lawyer shall not knowingly reveal confidential information as defined in the rule, or new such information to the disadvantage of a client or for the advantage of the lawyer or a third party. Under prong C, a lawyer shall make reasonable efforts to prevent the inadvertent, unauthorized disclosure or use of unauthorized access to the information that's protected. And this is really where generative AI, when we're looking at this rule, this is where we have to look at the impact of generative AI. Inadvertent, unauthorized disclosure or use of unauthorized access to the information. And Ron had touched upon this when he was talking about the information that's inputted into ChatGPT. So examples in which this can occur is directly using ChatGPT. So the user directly inputs a prompt into the system, and it contains perhaps private or confidential information, which then goes into the ChatGPT. There could also be indirect use, which some of the audience members had mentioned in their questions. Indirect use of ChatGPT that's embodied or embedded in search engines that we might not even realize that we're utilizing, and therefore can expose confidential information that goes into the generative AI app. There's also application program interfaces, or API. Using some of these applications that connect to GPT on the API can also reveal private or confidential information, as well as plugins. Accessing other applications that from within ChatGPT via plugins which convey private or confidential information. And so this may expose this information to third parties, to others who may see it, also our adversaries. So pursuant to the New York Rules of Professional Conduct, lawyers must take reasonable efforts to prevent these inadvertent, unauthorized disclosures or access to such information. So what can attorneys do? What should we be aware of? What can we do to better understand this technology? Well, some of these have been mentioned in terms of looking at the terms of service agreement, really looking at them. How is the data, your client's data, being used, being shared, possibly spoliation issues, how long do they maintain access to it, privacy policies, licensing information. Another good resource of information is the frequently asked question list. A lot of information from those questions that are being asked are very helpful in analyzing these tools as well as the vendors. So again, data that is supplied or inputted into the ChatGPT may be used for training purposes. We've heard of that in helping the model, to improve the model, and therefore you're exposing your data to others than you may realize, who are here, you know, again, they're utilizing this information to improve and develop their systems. Data that is supplied to or inputted into ChatGPT may also be viewed or disclosed to third-party vendors or parties, also in training AI model. And then the data output of ChatGPT may be viewed by third parties, including opponents and adversaries. We see this in terms of the open system. If you're creating a prompt and inputting it into an open system, the output that's developed, if someone comes after you, let's say an adversary, or even someone else, and kind of conducts the same particular type of search, they may have access to the output that you generated. And so again, we have to be really cognizant and take, you know, kind of take this all, understand it all together as a whole. When we're utilizing this system, the benefits are there. They're great. They're wonderful. You heard that in the first panel. But we cannot forget it's a tool. It's a powerful tool. It's a helpful tool. It'll help in decision-making, efficiency, improving client relations with the lawyer. But this tool also has its limitations. The hallucinations, or, you know, when I speak to my classes, I heard this great line, to remember that, hallucitations or hallucitations. And that's something to keep in mind, and that's a helpful way of remembering the limitations or the negatives that can occur when utilizing this tool. Moving on to conflicts, rules 1.7 through 1.12. In terms of conflicts, when we looked at that first list of the use cases with AI, we looked at the repetitive nature of certain tasks. And, you know, when you think of an assistant, if I had another pair of hands, even the paralegal or the legal assistants, if they could delegate some of the responsibility to another person or a tool to help them, this may be, in the conflicts case, possible way of utilizing to, again, make sure that there are no conflicts of interest with current clients, past clients. I think lawyers are very mindful of this because of reputational harm and financial harm that may occur because of conflicts. But again, even in the conflicts area and possible use of this case, what I think about is also possibly revealing client information, even the name of the client, right? That can be an issue. I just remember back in the day when I was a law clerk in bankruptcy court, a long time ago, and the newspaper, you know, the reporters would come to the clerk's office and sit there waiting for the next filing. And I remember the practitioners saying, with the high-profile cases that were occurring at the time, such as Eastern Airlines, saying that even those who were working on the papers, working on the documents before they got filed in court, all of the pertinent client information was redacted. They did not even know who the client was until the day of filing. Only those on a need-to-know basis did. And so I think about that, even with the conflicts checked, even perhaps in a closed system, there are security issues as well. Not only the limitation that the closed system might not work on as much data or have access to as much data, but also the limitation in the sense that, the issue in the sense of security. You know, hacking is still an issue. Cybersecurity and AI are intertwined that way. We can't forget that. And moving on to client consent. That's something that we need to think about when utilizing these tools. General consent, specific consent, case-by-case basis. These are things that are being debated and discussed in this space. Again, with client consent, a lot of great things that the panelists have already said in this panel and the first panel in terms of discussing this with your client. You know, clients might have unreasonable expectations in terms of what this technology can do, at least right now. And so perhaps doing a cost-benefit analysis or showing what are the benefits as well as what are the limitations. Some of them were mentioned, quickness, speed, possibly cost savings, but that could also be a detriment. Costs can go up in terms of, it might not be as cost efficient. There's also issues of transparency, which was mentioned, and not knowing what goes into the decision making. Ethics and bias and discriminatory practices, intentional or unintentional, can also weigh into that. So I think this, whether we should have this informed consent, another layer or another issue is if you do choose and your client does wish to utilize or wants you to utilize this technology, how are the providers of the AI? How are they ensuring to you that they're securing the systems? How are they alerting you to any hacks or possibilities of vulnerabilities? Are we communicating enough with them? And that's the nice interdisciplinary nature of law. Are we communicating enough with these vendors and these IE system creators so that they understand our concerns in terms of our professional responsibilities and duties and always maintaining client confidentiality of their information?
Question for the audience. How many of you, if any, include any reference to use of AI or generative AI in your engagement letters? Oh, you, sir, are a maverick. You seem to be the only one who is that future thinking. Later on, Ron will talk to us a little bit about the Florida and California advisory opinions on some of this. But
can I just add one
no,
thing? Yeah.
absolutely.
I was going to say for the client consent issue, I think it is interesting, and Mercer, you mentioned it may be the other way, and I do think not yet, but within the next couple of years, it more likely may be clients saying, why are you not using generative AI or requiring use of generative AI to have a first draft of a brief rather than 40 hours of a first-year associate. We're not there yet, but my personal view is that's somewhere where we may end up in the coming years, where there, it depends, of course, how active in-house counsel is. But I think we had predictive coding, which has been around on the litigation side for 10 years now, and it's used, but not to the extent people thought it would be used, or it's not required necessarily by a lot of corporations or clients. This, I do think, is different, where it's more understandable the potential cost savings. And again, we're not there right now where you can necessarily see the cost savings, but as these tools improve and become more complicated, more efficient, I do think we're going to go that direction.
I think my concern really is the anti-Avianca case that's still pending. So we've yet to see the other shoe drop, where a less than savory defendant lost his case, but his lawyer was very proud that he used some type of generative AI tool to generate the closing argument. So now this defendant is arguing that he should be entitled to an appeal because his client did not inform him that he would be using this tool. That's a bad potential outcome of this. This is the opposite of saying that you relied on hallucinated cases. This is you relied on potentially good prompts to help you become a better lawyer. Your client just sucks and your client needed to go to jail. But now are you going to be able to use that potentially for a defendant as a method for appeal? It is something troubling. Ron, I was wondering if you could take us through a discussion of a couple of the other ethics rules that are implicated by generative AI tools.
1.3, pretty simple and straightforward. Duty of diligence. You may be in a situation, as Ignatius suggested, where your client is going to expect you to use these various tools. And frankly, to me, all of these things we're talking about, at least 1.3 and 1.4, have to do with the conversation you're going to have with your client. Are you going to talk to your client about what tools you're using? Do you talk to your client when you do a data search? I don't know. I don't know if I have a good answer for that one yet. When do you begin to say, I'm going to tell you I'm using generative AI to write a brief or to do research and the like. So that's one question that's open. I don't think we have an answer on that one yet. Duty of communication, again, advising clients as to what you're doing. I think there may be degrees more than anything else. My biggest issue in this space, quite frankly, is when you're going to be told by your clients you have to use this tool. And you may not be familiar with the tool. This may be a situation, Marissa, you alluded to this before, where you need to have a conversation with the client as to exactly what the tool is and what the tool does. And before you do that, you have to understand what the tool is if the client's telling you to use it. So I appreciate this may be helpful, but I also appreciate we have to start thinking about what it means to get informed client consent to use these tools, and what do we do when the client wants us to use their tools. So that's a start for that. Unauthorized practice of law. I understand there are a lot of people who say that GAI and AI are going to improve access to justice. I'm not sure, at least in the short run. Everything we're talking about now is going to require experts. Experts to inform you, experts to advise you, experts to do a lot of things, maybe to prepare discovery. Forget about being Rule 702 experts if you're in federal court or the equivalent in New York State. I think that's going to drive litigation costs up to some degree. I don't know where we're going to go with that. You're going to need experts to testify about some of this stuff in court. Unauthorized practice of law specifically, it may be one thing to have a platform that fills out a form. What happens when you have a platform that says, based on what you're telling me, I think you should bring an action on, pick a statute, any statute you want to, and bring a lawsuit. Is that legal advice? I don't know. It probably is, quite frankly. And there is litigation pending across the U.S. now brought against some providers, arguing they're engaged in the unauthorized practice of law. I'm not suggesting whether it's good or bad to have platforms suggest what pro se litigants should do or poor litigants should do. But it's something we're going to be confronting, at least our ethics agencies are going to be confronting in the next few years.
So what make you a first panel that said they're going to solve this hallucination problem, and your Joe Blow pro se applicant or plaintiff is just going to be able to use one of these generative AI tools, basically no need for lawyers?
There are warnings that have gone out now from individual judges across the country in their chambers practices about pro se litigants using these tools.
MCLE verification code A.
There's an order that's gone out now from the Northern District of Ohio. I believe that's the district court, about the use of tools by pro ses, whether they can be used or not and what kind of disclosures have to be made. Mm-hmm. The problem is you're relying on, the pro se litigant is relying on a tool to give him or her examples of case law. Is the pro se going to look up those things? I don't know. If the pro se doesn't and it gets submitted to a federal court, that's a violation of Rule 11, probably, of the Federal Rules of Civil Procedure. If it leads to discovery, it's probably a violation of Rule 26G1 of the Federal Rules of Civil Procedure. So I don't know how this is going to, this goes back to access to justice for me, how people are going to be able to use this if they don't, quite frankly, if they don't even know how to do legal research. And they may not. They may rely on it because it's coming from a platform, it's got to be right.
Well, that sounds like a techno-solutionism response to it. And that's when we inaccurately decide that technology is a solution for any access problem. And that is rearing its ugly head now really strongly within this profession because we do have an access to justice problem. We're going to delve into that a little bit more because it's not just a simple matter of the affordability of the tool and the competence of the attorney, but there's the existence of the digital desert. But before we hop there, any further thoughts on UPL or the ethical rules? I want to get to other fun ethical rule, the duty to supervise. If you don't recognize this as a failing in the Mata v. Avianca case, I dare anyone to write down how many times we said the word Avianca during the day today, during the summit. I guarantee you it's at least more than a couple of dozen. But Marissa, what implicates a duty to supervise if you're talking about your junior attorneys within a company or a non-lawyer?
May I ask a question of the audience before we do that?
That's your question.
Does anyone not know what MATA is about? Does anyone not know MATA? Okay, everybody knows it, so go ahead. We're fine. There's one person.
No, there's one.
Okay, there is litigation pending in the Southern District of New York. There's motion to dismiss made. The plaintiff responds by sending in a brief. Defense counsel writes to the court and says, Judge, I don't know where these citations are coming from. I can't find them, or they're wrong. The judge issues an order to show cause. The attorneys respond and say, Judge, we used ChatGPT to write the brief, and we know it's right because we went back to ChatGPT and it told us it's right. That's what they said. And the judge here in the Southern District imposed sanctions under Rule 11 of the Federal Rules of Civil Procedure and said that if that didn't apply for one reason, I'm using my own inherent powers to apply sanctions against these attorneys. We've seen other examples of this at the state and federal level since then, but lawyers are relying on these tools to write things, and they're apparently not bothering, in some instances, to read what's been produced. That's all.
And if I can briefly comment on the duty to communicate 1.4, also in terms of speaking with our clients, continuing conversations with our clients and communicating effectively, clients want answers. They want to reach us in what's available to them, the modes that they're comfortable with, texting, WhatsApp, etc. I think it's for us to say that we're here to protect the information, your information, and we do want to communicate as best as we can, but we want to do so in a means and a mechanism in which we can control and know and have some certainty in terms of security. And perhaps there may be things that we can use alternate means of communication, if you're comfortable with that, but not for every type of communication. And it's all about maintaining privileged and confidential information of the client, protecting their data. And in terms of due diligence, as we stated, there may be a time, and maybe not so near future, where we will fail on our duty of due diligence if we don't utilize these tools. But moving on to duty to supervise, in terms of supervision of both under 5.1, other attorneys, and 5.3, supervising non-lawyer work. And in the Mata decision that Ron just referenced, the Southern District of New York case, the non-lawyer was actually the AI tool, in terms of supervision. So we have an obligation to supervise lawyers, to supervise non-lawyers. My question always is, in order to supervise effectively, you need to know, you need to understand the tool yourself before you can supervise someone else in that field. And that could be a learning curve, and it gets us back to competency 1.1 in terms of understanding the technology, the risks, and the benefits of utilizing any technology in order to be competent in that. And that could be something where it's kind of an up-down approach in terms of leadership, learning. That's what I encourage my students. This may be an area in terms of computer and being savvy with it. You grew up with it. You're more a native to it than perhaps I was in terms of law school and learning. Didn't exist. And so this could be something where we can share the role in terms of learning. But again, it's important to understand our obligations and our duties in respect to the rules of professional conduct.
So let me ask you, Marissa, you're my partner. You told me to use ChatGPT. You said, you need to get this done by the weekend. You're very strict. And I said, I'm going to use whatever tools I can avail myself of to very quickly get this thing done. But you knew I did it, and you submitted the brief in full now. So I'm not responsible under the ethics rules, right?
No, sorry. Again, I told you I was the no parent. I'm the no parent panelist, the rule-based panelist. If you are an attorney, you are independently, separately, and apart from me responsible for your actions. So yes, definitely me, there's no question there, but you as well, because you have your own, as an officer of the court, you have your own responsibilities. So yeah, we would both be responsible.
And if I could just add, this ties back to the policies and kind of, important to think about having the guidance out there for your associates, for your attorneys, perhaps having training on how these work, and if you don't have someone at your firm that's knowledgeable, that understands, maybe work with a consultant, someone to help out, to advise the firm if you are going to be making use of this, or even just to have, again, that framework, that policy in place. And one other thing is, I think we're here at the NYSBA annual meeting. The judge in the Mata versus Avianca case was Judge Kevin Castell, who happens to be a former chair of the Commercial and Federal Litigation section. And he actually, that case has now been resolved, and he spoke recently at a panel at St. John's Law School. And, I think he's, he knows this technology is out there. I think it's, those cases kind of have scared people, and I think, not to speak for him, but I do think he's of the view that this is a new technology that's going to potentially help lawyers, but you have to keep in mind these ethical rules, and obviously the lawyers in that case didn't use the technology the way it should have been used, especially at this point in time when we know there are hallucinations that do happen with the technology.
It's an excellent point, having the policies in place.
So California, not to ever be second in line for anything, and our Floridian friends, for all of you snowbirds, have already come out with a couple of advisory opinions to their bar, advising them on particular things that they should start considering. Ron, would you take us through a couple of things that are going on in California and Florida below?
These are recent developments. California just adopted a set of, these are guidelines that have been put out for attorney use of generative AI. Just Google it, you'll find it and it's in our materials, I think, at least a reference to it. I think the takeaway from all this is, if lawyers are going to be using this technology, this is like trust but verify from the Reagan administration back ages ago. You can't just take whatever the product is and turn it in without verifying that it is what it purports to be. And one of the other takeaways from California to me is understand the technology you're using. We're only at the beginning of this. You've already heard, I'm sure, New York State run by you. We have a New York State Bar Association task force on AI. I'm a member of the New York and the New Jersey task force on AI. We're going to be looking into the same thing as time goes on. We're in the process of doing that now. And when do you think we may have a draft report out?
Well,
maybe.
We'll have a draft report out on February 26th, out to all of the various sections for comment. But I'm curious for a panel, since people starting to weigh in, is it premature for a bar like Florida to say, you need to really start examining what your fee structure looks like? We already heard from our experts earlier, but billable hour is dead. And I was speaking to another practitioner who was on our task force as well, and she says, I don't believe in the billable hour. She factors in the ability to use any technology. If it makes her more efficient, she puts that in a flat rate. You can get a very good sense as to how long it will take you and how much it should cost. Is that our pathway?
Well, let me mention about Florida first. The Florida Bar Board of Governors is voting on a draft set of guidance tomorrow. So I expect by tomorrow this guidance will be in place in Florida. I have not seen anything that's going to suggest to me it's going to be sidelined one way or the other. Basically the same. Frankly, I think the key of this, again, is the lawyer has to have input at some place. So the lawyer is the one signing something, and it's verified to the extent you can by the lawyer. And at the same time, there are suggestions about competence and confidentiality and the like. As I said, New York's going to have something out, thanks to you, very quickly, I assume. And I think this is the first wave of regulations we're going to be seeing. There is a judicial ethics opinion out of, I'm blanking out, I think it's Nevada, that just came out talking about judicial use of GAI. And I expect we're going to be seeing something on that front too as we go forward. But the centerpiece of all this is if you use the tool, you have to stand by it and be able to verify it. And that goes back into the question of supervision, because that's another thing that these ethics opinions bring out. And Marissa and I had a nice discussion with someone at an IP section meeting a little while ago about what does it mean to satisfy you're supervising an AI platform. You're retaining an AI platform to do something for you. That's a non-lawyer assistant. You have to supervise it under Rule 5.3, and we could spend a couple hours talking about what that means, but there's something else to think about. The other area, I think, in this that these ethics opinions have skirted on and really not talked about that much, and we're going to, is the level of informed consent. I mentioned that before. What kind of consent are you going to get from your clients to use this? And then billing practices, I think, is going to be a major area of interest. Let's say for the next couple years, what ethics opinions are going to be saying about what you can bill and what you shouldn't be billing for when you're using one of these tools.
Any thoughts on this, Ignatius?
Yeah, I was just going to say, I think it's different, but I feel like for social media usage, you go back 10 years, I think we're going to see a similar ethics opinions that will come out soon that maybe are, to your point, Vivian, a little premature, that maybe superseded down the line or not really matching the technology. That being said, I do think it's important that there be some guidance here. So I understand why states and bar associations or ethics boards are trying to kind of weigh in. But it's going to be hard. I think it's going to change. As the prior panel said, it's going to be a different world 5 years from now, 4 years from now, based on this technology. So it is important looking at the future to know what the guidance should be.
So the literal crystal ball here, hallucinations. We have beat Avianca to death now. You've now hit the 24th time we've mentioned that word. So we won't talk very much about hallucinations unless the panelists have a couple of additional thoughts around the solutions on it.
Not hallucinations, but just back to the advisory opinions. I know California Bar, they're suggesting a CLE on AI, and I know the New York State Bar Technology and the Legal Profession Committee that both Ron was the chair, I'm now the vice chair of, they were the ones who had suggested the CLE credit in cybersecurity and ethics. And I think very much what Ignatius was stating, I see the interplay between cybersecurity and AI, and so when you're looking for guidance, there's the National Institute of Standard and Technologies, similar where they provide a framework or guidance in that area. So I think it's very helpful for us right now when things are in flux, so to speak, and we're looking for guidance and we're looking for ways to better understand this, to have some advisory opinions in place out there, flexible enough to adapt to the changing times and what may occur in the very near future.
The other thing I think we're going to be seeing very quickly are regulations coming out on AI use that you and your clients are going to be stuck with. And I think we're going to see local legislative initiatives. I don't see much coming out of Congress, realistically, in this space. But how many of you know about the New York City artificial intelligence law? Okay, if you do business in New York City or you have a client in New York City, it went into effect in July. And if your client uses AI to make any hiring decisions, your client, among other things, has to do audits. I don't know if a law firm is subject to that law or not. I think it is. So if you're using AI to do interviews or whatever, I think you may be subject to that law. So just something to think about where you're going to be going with that. And that requires bias audits on a triannual or annual basis. I think it's triannual. I don't remember. But that's something else you're going to have to be looking at in the future, because your clients that are subject to that law, and you maybe, are going to have somebody to do a bias audit for you. And I don't remember which New York City department just issued regs on it, but they're regs about what the audit should look like. And that's a common theme we're seeing now in resolutions that the FTC has entered into involving new technologies, that there have to be assessments and audits being done on a regular basis. That's something I think everybody's going to have to get into in the world of AI and GAI now.
And when looking at that, I'm sorry, when looking at that law really quickly, there's also the notice to the employees and potential candidates, as well as the auditing requirement. It's its first of its kind in the jurisdiction. But the question also becomes, the AI hiring tools that are being employed by the employers, they don't create it. So they're relying on outside vendors. So they have to communicate in terms of following our ethical responsibilities in terms of bias, transparency, and understanding the tool. So if there's any question, again, there's that, a responsibility of that the vendor and communicating with the vendor our concerns in terms of the law when utilizing such tools.
So someone asked a question earlier, what is my daughter going to be doing in law school when she comes out with her law degree? As we've just discussing here, and you keep seeing swirling in the news, we're creating brand new cottage industries as a result of this. We very cavalierly put into a law that something needs to be audited. Who's doing this audit? Who has that level of expertise to be able to discern what it is that it is good output or good analysis? So someone is going to need to be trained to do that. I am hoping that that will be my son who's contemplating law school, so he will not be living in my basement. But the reality is we are going to have to create brand new jobs to do some of the things and some of the regulations that I think on some respects, very premature if you start talking about audit. I'd like Ron to share with us some of the judicial reaction to AI in the courtroom. But before he does, I just wanted to share with you a concern that was brought to me. I'm in the appellate division in Brooklyn. They're having an AI symposium. Like, getting feet wet, love to see that. And I mentioned certain things are said in the room and it gets really quiet and eyeballs get really big. But the concept that it's like, what am I going to do, and I'm a matrimonial justice, if someone's bringing something like deep fake level evidence? How am I going to know? How is this going to start complicating my practice? I mean, he's really concerned about a potential Avianca, but not just the Avianca now. When you think about the enemy of the state, the surveillance state, the ability to use facial recognition technology and to create not just still images, but moving and visual and video and voice images and audio, fake. Ron?
Well, number one, this is going to be a great area for discovery because you're going to ask in discovery what evidence the other side has against your client, or you may be producing generated things. And that's going to raise, again, the need for experts because I doubt you yourselves are going to be able to go into the source code and all the metadata that's gone into creation of an image. So that's issue number one. Then you have authentication problems once you're past discovery. There is a proposal to amend the federal rules of evidence to put in a new authentication subpart under Rule 902 about generated AI. I don't think that's going anywhere. Because I don't think the Judicial Conference wants to start creating a rule for every new technology that comes along.
What about watermarking, Lon? Will that work? Watermarking, will that work?
Say again, I'm sorry.
Watermarking?
There are watermarking tools out there. Look, I'm sorry, if someone's offering stuff against me and they say it's watermarked, my first question is going to be, I want discovery in that because I want to know whether or not the watermarking is accurate. And you're entitled to get that, I think, under the federal rules. I think you're entitled to get it under New York practice. Criminal, let's leave that one aside. That's a whole different topic to go into. There's a big debate going on whether we need new ethics rules or whether we need new civil rules or whatever on this. I'm not a fan of new rules, generally speaking, but that doesn't mean we're not seeing them come along. And we're seeing them already. So, but that's mostly individual judges doing things. There's one Fifth Circuit Court of Appeals now has a proposed AI rule, the GAI rule, that's being voted on next month, I think. Several district courts across the U.S. now have local rules, bankruptcy courts as well as district courts on generative AI. And a number of federal judges have their individuals' chambers practices. And if you're litigating in federal court, remember, you're bound by the federal rules of civil procedure, you're bound by the local rules of the district court, and you're bound by the individual practices of the judge you're in front of, whether it's a magistrate judge, a bankruptcy judge, or a district judge.
Well, that's kind of disconcerting, Ron, because now you're talking about a potential mismatch of different rules that we have to follow. What if one judge says this is prescribed in my court, and the other one like, bring it on?
Well, that's different.
It's like state privacy
We
laws.
That's different. Individual judges do a lot of individual things that don't conflict. They can fill things in. They can't constrict them. How's that? It's probably a good way to describe it.
So we've been alluding to this concept of access to justice, and there was a suggestion in the first panel that it's coming. Like, we're really going to talk about this expansion. But as we started to discuss, and I'm going to have Ignatius take us deeper into the weeds of how pervasive this potential problem is to solve, and that AI may not necessarily be the solution. Ignatius?
Sure. So, I mean, access to justice is a big problem that we deal with in the legal community. There's just a large percentage of people that do not have lawyers. That I think a large percentage of people don't have access to lawyers in their community. There are a lot of pro bono organizations that don't have the resources to deal with the number of cases that come to them. So one of the things that I think there's a lot of potential here with AI, with generative AI and access to justice. Some of we go back to some of the uses. One of the uses is kind of a legal chatbot that helps give guidance, and this can be used by law firms and kind of doing work. But in the pro bono context, or in pro bono organizations, a big problem they have is client intake and figuring out which cases they can take, what the case is about. I think for usually the way to do that is have someone take a call, have someone meet with the client. Now it's with this technology, you can use generative AI. There are already uses out there of having, kind of incorporating all that information to kind of help the pro bono organization assign the case, figure out if this is a case that might be successful. So there's uses by pro bono organizations, and what I would say is not that it's coming. It's really already there for some. There've been a lot of panels where there's been discussions about how it is being used already. As we've talked about the technology improving, it's only going to become more, possible. So then there's the client intake, there's the legal research part of this, there's the drafting of documents. Let's say a pro bono case you want to file in multiple states. It's going to be much easier to alter your complaint to file in multiple states. That gets to another issue, which maybe is a little outside access to justice, which is, will there be a lot more cases being filed? If it's easier to file cases, what will that mean for our court system? And that's even, there are a million kind of possible ramifications of this technology.
We'll just invent robo-judges to do the robo-cases.
That's the other part of this is people actually, it's surprising, but some people, you ask them, would you rather have a judge, a human judge, or an AI judge? Some polls, actually, you'd be surprised the number of people that are okay with an AI judge. It's not there yet, but you can see where small claims courts that maybe you have to wait a year to get your case heard. Now you have the choice of having your case heard within a month if you use a chatbot judge. We're not quite there, and that's going to raise plenty of issues, but the technology is going to allow that. The question is, what will the legal community and bar associations and courts, how will they deal with that? But yeah, I mean, it's something to think about. If when the courts are overwhelmed, it's something to think about. But again, you have uses by pro bono organizations. The question, which was raised in the first panel, is, will there be a cost issue? We don't know. I mean, I think that's it's a concern, because you don't want to have it worsen the situation where low-income plaintiffs or where pro bono organizations don't have the resources and the disparity becomes greater. But, you know, the hope, as has been mentioned, is that eventually the pricing will kind of even out and it's not going to be prohibitively expensive. The hope is for organizations to take advantage of some of these technologies.
So can you speak to the digital desert? Because that's also a current infrastructure challenge.
Right, and you know, I guess the other part of this is the use by individuals, which is like for client intake, but also guidance. You know, without getting into legal advice, you know, there are already going to be tools out there about, you know, and people already do it. I guess that's part of what I have come to the realization is you go on Google, you go on the web, you know, there's stuff out there that people can find. You know, in some ways, this is a different interface that better enables them to kind of capture that, and it obviously goes a step beyond that. But you know, as far as the the digital desert, I think that is a concern. Is are people who need these tools going to be able to access them? And that's a big question, and how you can make that more possible. You know, there are courts, I think they're putting in place stations where people will have access that would enable them to take advantage of some of these technologies, but that's going to be a big challenge.
Any other thoughts from panelists about access to justice? Is this coming in 18 months?
Just a few, if you could. When we were in the pandemic and courts were remote, building on something Ignatius said, rural populations in New York State and across the country and disadvantaged populations could not participate to some degree in virtual proceedings because they didn't have secure internet access. So if we are going to go down this great road, someone's got to pay for it to make all these stations available. Any legislators here? Put some money in the budget so that we have money to support rural populations and poor populations, and put some money in the judicial budget so we can start having these different type of technologies put in courts. So it sounds like it's a great thing. I talked about this a little before, about the digital desert, digital divide, and quite frankly, it comes down to resources. So find the resources for courts and for poor people and rural populations to participate in all this, and we'll see what happens. But we certainly are not there yet.
And I just wanted to add one thing I wanted to mention, which gets back to what Ron had spoken earlier about the unauthorized practice of law. You know, that's an interesting area where if you actually look at OpenAI, which is ChatGPT, they actually have a clause, prohibited use, engaging in the unauthorized practice of law, or offering tailored legal advice without a qualified person reviewing the information. Now, for what that's worth, you know,
no one's reading that fine print.
No one's going to read the fine print, but you know, I think they're going to make that effort. You know, obviously, people use this technology in various ways, and it's going to be difficult for that to be regulated. So it's again just something we're going to have to deal with and think about. And you know, it's happening in the medical profession as well, where people are going out there and asking, you know, I have a headache and my knee hurts. What's wrong with me? Or you know, getting it, you know, kind of medical advice, coming into a doctor's office saying, I think I have this. You know, lawyers are going to have to really deal with the same sort of issues in some way or another, you know, as long as this is out there available to the public.
Well, let me give you another great example with that little thing on the bottom. If you have to agree to it as a click wrap or as a browse wrap, and whether it is or it isn't means you may or may not have a contract formed. So that goes to cybersecurity and your competence to even deal with those issues. All these things are tied into competence whenever we're dealing with technologies now, no matter what the technology is. And we're going to be seeing more and more issues about this as we go forward with everything. So we did have a question in the front.
Oh, please, question, ma'am.
So, according to Judge Forrest, we're getting to the point where the hallucinations are becoming less of a problem. And the AI algorithms, machines, whatever, can teach themselves. So how far away are we from, I didn't know that there was a term called an AI judge, but don't leave the courts. You just pop it in, and everyone has agreed this is the data, and you get an answer.
If I can repeat her question before our panelists answer, the question is, how far away are we really from AI court, where we have an agreed data set, let's say a agreed statement of facts as between the plaintiff and defendant, that we can reach an adjudication without the need to have this whole lengthy charade of a full-blown litigation? Anyone?
Well, it's funny, one of the issues I was going to raise, I forgot to mention, with regard to access to justice is, the idea of getting advice or getting answers from a generative AI, one of the challenges is, people have so many different issues that may affect their, another area. So let's say it's an employment issue, maybe their family issue or other issues will make, advice not as helpful based upon kind of the whole picture. So, I think, as far as an AI judge, there's so many issues that would go into, some cases. A small claims case, maybe that's a different story, but a more complex litigation, I think, most people would say that there's, under any circumstance, they'd want a human judge. But as far as how far away, is that really the question that you're asking?
Well, it is, but I'm a litigator, and I tell my clients all the time about gastronomic jurisprudence. But isn't that what we want to avoid? Right? We don't want your ultimate verdict to be because someone on the jury wants to go home to a sick child or because the judge had a bad burger for lunch.
We have that already. It's called arbitration. It's a way to avoid courts.
That's when the judges always have bad burgers for lunch.
Depends on your point of view.
Oh,
I don't
Sherry's
have
at the microphone.
I don't have an answer to it. I wish I did.
Sherry, please.
Brazil, for example, and you pointed this out to me yesterday in an article, Brazil is experimenting with having AI decide cases because there's thousands and thousands of cases in a backlog. If you and your client think a computer will give you a better answer than a human being, go for it. But make sure the contract you have with the other side is something that's enforceable. Ask me in 5 years.
We'll ask you in 18 months. Sherry.
I can't.
Sherry, before you.
I would say I can't predict as well, but I'll bring us back to the rules. Rule 5.4, professional independence of a lawyer. When I think of this, I think of two quotes. Abraham Lincoln once said that lawyers' time and advice are their stock in trade. And also, in the message that was communicated by Chief Justice Roberts in the year-end report, he discussed optical technology. Rather than human line judges, he said they now determine whether 130 mile per hour served is in or out. The Chief Justice says, so that he notes that there's no discretion. The ball is either in or out, hit within the line or not. By contrast, legal determinations often involve gray areas that still require application of human judgment. So I think we have to keep that in mind as well when we're talking about AI. I have heard internationally as well in ADR that they're experimenting with AI judges.
Mm-hmm. And Ms. Levin-Wallach.
Thank you, and it's great to see all of you, my wonderful esteemed colleagues who I work so closely with. I'd love to hear your thoughts on a comment that I keep hearing in this regard. And Marissa, you actually touched on it just briefly in the quote from Judge Roberts, which is that AI does not have the ability to provide empathy, to be subjective, to comport with what we consider to be ethical judgment. And so when replacing, or the thoughts or discussions of replacing judges with AI or AI judges, however you want to look at it, those are some of the things that I think are continuously being discussed, and I'd love to hear your thoughts on how that will impact and what type of impact that's going to have moving us forward, and what cases and types of situations might be more appropriate or less appropriate as a result of this. For example, I know in the criminal justice community, things are being looked at in California, like using AI to make sentence determinations and to make determinations on to whether somebody is eligible for parole, let's say, right, because of risk factors. So I'd love to hear your thoughts on that.
Federal judges have used computer programs to help them in sentencing decisions and in pretrial release decisions for years. It's called Compass. And a program is put together, it makes recommendations, it goes to the probation or pretrial services people, they send it to the judge. There's usually a range or a decision has to be made, and it's discretionary for the judge to release someone, for example, before sentencing or before conviction, I'm sorry, not before, yes, before conviction for pretrial bail. It's a tool. You mentioned this before. The judge gets a lot of information. There may be a recommendation made, and it's the judge who's the decision maker. And you all tell me if you're going to go to prison, whether you would rather have a computer decide whether you should be released before you go to jail for 10 years, or would you rather have a human judge make that decision? And I think that's what a lot of this is eventually going to come down to, frankly. I don't...
Sir, at microphone? You were going to keep talking about your crystal ball. I don't know. Sir.
Hello, everyone. My name is Lin Fei Wu. I was asked a question previously. I'm the CEO of the Anytime AI. So we built an enterprise co-pilot for legal professionals. I'm an AI scientist. So I'm a master inventor of IBM 2022. But I'm not a lawyer. So I was humbly to ask, so in our product design, so we value human machine or human AI co-work mode, in the sense that so the AI should do the initial work to digest the documents, to extract key insight from the document, and also to draft the initial draft, and to automate the workflow. But we think that the lawyer or the user should be ultimately the one who to review the document, to verify the answer, to polish the final result, and then most importantly to approve the result. So I'm just wondering, so in your opinion, is this the right direction that we think the lawyer and AI should work together, or we think that ultimately we will let AI to take over the lawyer's job?
Yeah, so no Terminator here. The whole idea of a tool, period, is to supplement, not supplant. And I think as many of the doomsayers may say, I have a friend who works at Google who told me to get my affairs in order because we're going to reach singularity in 3 years. That's the bad news. The good news is you only have 2 years left because she told me a year ago. But if we continue to think of these things as tools, as things to make us more effective, as things to make potential access to justice a reality as opposed to something ephemeral, like that, there has to be that human element helping develop this as well, and also raising the flag if we see things going off the rail. Any of our panelists want to speak to that question?
I think that's exactly right. I mean,
he likes that answer.
It's it's a tool, and I think no one's, we're not, I don't think we're anywhere near the point of having an, AI lawyer that's going to file your, someone could get a complaint, but, you need to have, we all know how complicated a litigation could be, or on transactional side, how complicated negotiations can be. I think what this is doing is, to your point, providing that first draft of a brief, or providing, first a template contract, but that's I think the way it should be, treated by attorneys and by people, as a tool, not as a replacement for anything.
And just in terms of security features, that they would be protocols in place, updates, notifications, if there's any bugs in the system, and things of that nature. But again, when you talk about content editing, that someone's going to take the end product and be responsible to go back in and look at it, what you need then is experience and wisdom in order to do that. So if we become over-reliant on the technology, will we lose those skills and knowledge base that we need in order to as you say, go back to the output and be able to input important information. So that's something that we need to think about as well.
Thank you so much.
And thank you.
Thank you.
Young lady.
I'm a transactional lawyer and a dispute resolution professional from upstate, from Albany. I realize some people think White Plains is upstate. And I'm a solo. And this discussion is quite frankly terrifying. And I think that I am representing, from my seeing the nods around here, a number of people in this room. I've chaired a section of the ABA, and I know how many solo and small lawyers are members of the ABA. So part of the question is, how are we to have enough time to absorb this technology, which we clearly are required to do, and still practice our profession? That's the first question. And these are just thoughts that are floating. You don't have to answer, but it would be nice to hear your reactions.
I'll give you a reaction to that.
Yes, please.
The FTC is looking into generative artificial intelligence now, and one of its concerns is the effect on small businesses, because the concern is that the giants in the internet, whose names I will not say, are going to wind up monopolizing or quasi-monopolizing a lot of things in here. So that's a number one issue. It's going to be market concentration as opposed to new things as you go forward. More realistically for you, I think and I'm going to leave this for our chair to talk about, I'm sure that one of the things we're concerned about in the New York State task force is how solo practitioners and small firms are going to be able to deal with all this. I'd like to see us in a situation someday, personal opinion, where there are a list of, if not approved vendors, vendors that have been tested, that perhaps could be on a list of saying, go talk to these people, wouldn't release you of any of your ethical obligations, but maybe there'd be a couple that you could go to. Look, it's coming. I'm sorry, but it's
coming.
You know.
I teach at a law school. The law school is terrified that our students will hand in ChatGPT papers.
Oh, they're doing that right now, ma'am.
It's coming. Yeah. We all know that. But I'm just wondering, about some of the realities. Thank you.
Well, I was just going to add, I think, coming to a program like this is what you need to be doing, going to other programs, trying to understand what the uses are. I think the more that people do that, the better off they'll be. And I mean, I think if you think about it in the grand scheme of things, I think it's probably potentially going to help solo practitioners, small firms, just as much, if not more, than the larger firms in certain aspects.
In certain aspects, clearly, yes. But then you get into the situation, as we have with anti-bias training. Does 1 hour of anti-bias training a year really do the job? And
it's nice to go to a CLE and get terrified, isn't it? I mean, really.
I will say, probably the number one recommendation that will come out of our task force report is to address exactly her question. We need to allay the fear and instill the excitement. Because if you are not confident and competent to want to even start touching this, it will overwhelm you, and it will be the next generation that will come in with that level of comfort, but they won't have the level of training that you need to impart to them. If they become techno-solutionists, where they think, because we've gotten rid of the hallucinations, that all I need to do is plug a query into a particular tool, and they did not learn the reasoning and the rationalization that they should have in law school, then we have failed. Our true fear is that we didn't train the next level of lawyers how to use these tools as a supplement to their legal practice, not to supplant them in it. Assigning a simple task to someone does not obviate your obligation to continue to oversee it. So our number one focus is that education element, because the more you know something, 1 hour of anti-anything is not going to help you. We're talking multiple steps of even sponsoring multiple CLE and live webinars and putting people in front of their devices and saying, see what you can do. Create your own magic. See how this is helpful to you. I appreciate we're running to time. I'd rather take your questions. I just want to very briefly, if someone does not know this billboard, shame on you. You've been living in a cave. But one of the great use cases potentially, and I'm thinking more particularly for the smaller practitioners or solo practitioners, is to be able to generate more cost effectively, being able to do your attorney advertising, populating your blog, doing other type of social media content by being able to do a few click queries and create these wonderful images and great slogans, Better Call Saul. I was like, that was not AI generated, but it will be able to give you opportunity to think. So I just want you to think somewhat of a non-terrifying use case that we're proposing out there that may be able to help extend some practices. Sir.
I just want to share what is the most concerning to me. Our practice is an anti-fraud investigation and litigation practice. And as I'm listening to this, I think one of the biggest dangers will be the inability to decipher misinformation. And what we're talking about in terms of hallucinations, in a sense, that's easy. Hallucinations are rather obvious, but as this becomes more sophisticated, the ability to present misinformation which is not easily deciphered seems to me will become more and more difficult. And not to become overly political, I think if you marry that with what's happening politically in our country at the moment, it becomes all the more problematic.
The FEC announced yesterday or this morning that it's going to start looking into generative artificial intelligence in the context of the upcoming elections this year. Well, don't get worked up about this because there are organizations already criticizing the FEC, Federal Electoral Commission or Elections Commission, that they're not doing enough about misinformation. But we'll see.
Yeah, I mean, it's probably not as much generative AI, but I think it's the same issue. The technology is advancing so quickly. We haven't quite seen it, but it is kind of in the news. Matter of time till someone gets up, gives a presidential address, and it turns out it was a deep fake. I think it is important for us to kind of getting ahead of some of that, so that we can be prepared and have kind of guardrails in place for misinformation. Both in legal, but outside of that, politics otherwise. So I think it is a concern as technology continues to advance.
And this has arisen in the case of phone call scams, phishing, and social engineering, where we saw, a quote-unquote grandparent scam, where they believe they're talking to a grandchild, and the grandchild's concerned about something and needs money right away in a liquid form. And now with synthetic media, it's actually the child's voice. They can grab it from social media and be able to actually use the grandchild or the child's voice. So again, this deception and the ability or inability to understand whether or not it's genuine is a real concern. And on the point of training that our other questioner had raised, it's very much like cybersecurity. It's not just about training, it's about training and testing. So there may be something, and I think the business and finance world has done a lot in this space because of phishing scams and all the other types of social engineering issues, where it could be something as simple as the CEO or anyone at that C-level suite, they will never, ever, ever send you an email. It just won't happen. That's not how they're going to communicate. And therefore, anytime you see an alleged email from someone at that level, it could be, I'm not saying it's simple, but as straightforward as that, that's not genuine. You don't even have to look at the address and look at the .com or whatever at the end. It's just not going to happen. Or you can have a special code word or a color, and that can also, so sometimes a simple way of overcoming these issues. But every time there's a solution, again, there's there's some bad actor or something that, they're going to continue with trying to tamper with that.
Okay, so Marissa, you're not helping me with the
I'm
fear
sorry.
problem. So I'm gonna take the next question.
Good afternoon. I'm originally licensed in North Carolina, and I'm newly licensed in New York. As someone that practices in 2 separate states, especially those that are kind of very far away, what aspects do you kind of see in that interstate connection, or issues in that interstate connection that would be with AI, especially because you talked about New York city having its own law. Do you see 2 separate entities and 2 separate laws to keep up with, or would it really be a federal issue?
I think on the ethics front, I mean, it's going to be similar to social media in that you have, a New York ethics opinion, you may have a North Carolina ethics opinion, you may have a Pennsylvania ethics opinion, so you need to be aware of where you're practicing and what would apply on that front. I mean, I think Ron or Marissa had mentioned, federally, the likelihood of a federal law that kind of covers all this is probably not that likely. In certain industries, that would be the case, but I do think as a lawyer, you're going to be looking at the states that you practice in, what the ethics rules are, what the professional rules of conduct say. I don't know, Ron, you kind of are involved with 2 states. So.
Just one comment on that. After President Biden released his executive order on artificial intelligence at the end of October, he directed every federal agency to look into AI-related issues. The guidances and regs are going to start coming out, and that obviously is going to go across state borders if your agency or your entity is federally regulated. So that's something you're going to see. But beyond that, I think this is really going to be a state and local effort more than anything else.
Okay, and now, thank you so much. Extra credit for anyone who recognizes this archaic device in the background of my question slide. And I turn it over to you, Richard. Thank you.
So, in closing, I'd like to say 2 things. First of all, this panel and the prior panel have put on what I think is one of the finest presidential summits that I've ever witnessed. And I'm very proud to know the panelists, and I'm very proud of what they've done. The second thing I want to say is someone very wise once said to me, "Don't ever think you're the smartest person in the room." And after watching this program, I can tell you that I'm very positive that I'm not the smartest person in the room. So thank you all for being here, and thank you again to our panelists, and enjoy the rest of the meeting. Thank you.